you mute yourself, but yeah.
Hello. Hold on. I can't hear. Let me see. See what I gotta press here.
Sir, we can hear you fine. What's your name?
Oh, Gerald Cruz.
Thank you. Please mute your phone.
Hello?
Hello.
Yes, sir. I think I got it unmuted.
I'm here. Can y'all hear me?
We can hear y'all. If y'all can
Yes,
just
sir.
mute
Hey,
yourselves and wait for court for court to start.
okay.
All right.
message though.
All right, ladies and gentlemen, I have about 9 o'clock. I am having, as it seems to be usually the case, computer issues this morning. Please bear with me if this goes more slowly than usual. I'm going to call the criminal and then civil dockets. I'll ask for announcement from the attorneys. Any person who's present who doesn't have an attorney or whose attorney doesn't answer for them, please make sure I know that you're here. And if you're not actually doing that, please keep your electronic device muted. On the criminal side, State of Texas versus Audrey Roblevo.
Morning, Your Honor. I'm present for her. She is in custody. We have an agreement. Wrapping up paperwork. We should have that on file and be ready for hearing very shortly this morning.
Okay, I'll mark you conferring.
Thank you, Your Honor.
Give me just a moment. All right, is anyone from the coordinator's office on?
Good morning, Your Honor. Yes, sir, it's Norma.
All right. Oh, but you're on the phone.
I'm not sure why I added on there, but I can log back in again.
Okay, well, I was going to make you host, but I can't make a phone host, so. All right, State versus Michael Tijerina.
For President, Your Honor, will confer. It's an MTR.
All right, is your client there with you or?
It should be. I saw him on his name came out on the
Okay.
screen.
All right, Jacob Roy Salazar.
Judge, I'm present for him. He's in custody. You should have the plea paperwork, or there'll be a plea entered today.
All right, Ricardo Jaramillo.
Council President, Your Honor, defendant is in custody. That one will also be a plea. We'll confer and be ready on that one shortly.
All right. Mr. Arguello, you need to mute your phone. Okay, your announcement was that he's in custody?
Correct, Your Honor. Same, yes, and it'll be a plea here shortly this morning.
All right, thank you. Christopher Bryan. Says monitor compliance. Do we need to have him here today or not?
That was reset, Your Honor, to 12-1 for the DA.
12-1 of next year, I take it?
No, this year. I'm sorry, yes, sir.
Okay. All right. All right, Mr. Arguello, can you hear me?
Yeah, can you hear me?
Yeah, I can hear you, and I can hear a whole bunch of other noise.
Yeah, I'm at work.
I muted you once.
Eric, is this Eric?
Okay, Mr. Lambert, I'm speaking. I muted you once, sir. I'm going to mute you again. And if you turn your speaker on when you're not supposed to again, I'm going to remove you from this meeting, and you're going to have to show up in person from now on. Okay? Okay.
Your Honor, I'm so sorry. I think that's a witness for a later hearing if that's Eric Arguello.
Okay.
You do not need
Mr.
to be on
Lambert,
right now.
it doesn't matter. I'm
Okay,
calling
sorry.
the docket. Jose Garza. No show.
Judge, he's in custody, Judge, and that was going to be a plea this morning, but I had some difficulty with the e-filing over the weekend. I could upload the plea papers to chat if that's okay with the court.
Great.
But we're ready for a plea.
Okay. Aaron Seth Ray.
I'm present for Mr. Ray, Your Honor. Mr. Ray is in custody. This is one we've been working on. I've been working with Mr. Thornton for a while. We'll need to confer this morning. If we can just mark us conferring for now, Your Honor.
Okay. Andrea Webster. All right. No show. Christopher Aguilera. No show. Jesse Coronado.
Good morning, Your Honor. Mr. Coronado is in custody. We have a plea agreement worked out on that. We just need to get paperwork done. We'd like to set that for Wednesday's docket to enter the plea if possible.
Okay, 12-16.
Thank you, Your Honor.
Angelica Gutierrez.
Your Honor, we have a plea agreement on that. We should have paperwork turned in and she's in custody.
All right, and I'll let the DA's office know now. At the end of our docket, I want a total of how many pleas you're expecting today. Christopher Guzman. No show. Roger Talamontes.
Oh, sorry. Mr. Guzman? Is he not on? Your Honor, I sent an email to Kenny Lamb in regards to his case. We were going to try to get him on. He just got released from a rehab unit and he's currently in a sober living house. But I talked to one of his members and they said he would be on. So I'll get him on and make sure he's in here.
All right, thank you. Roger Talamontes. No show. Serafin Bazan.
Your Honor, Mr. Bazan is present with counsel. We'll confer.
Thank you. Luis Ambriz.
Your Honor, counsel's present. I believe he is on his phone. Mr. Ambriz, are you present? Mr. Ambriz? I'll check on him, Your Honor.
All right, there's someone whose phone number ends in 012. 0 is not muted. Who is that?
It could be me, Your Honor, Sheila Troxel.
What's the first name?
Sheila. Mr. Briggs is my attorney.
Okay, please mute your phone.
Yes, sir.
Your Honor,
Yes.
Roger Talamantes is currently in custody.
All right, thank you. All right, so Luis Ambriz, we're not sure about.
I'll check on him, Your Honor.
All right, mark him no show. Todd Olson.
Your Honor, this is Tim Roundtree. I'm present for Mr. Olson. I haven't seen him on this morning, but I'm trying to reach him.
All right, I'll recall, no show. Ernesto Velasquez. I see you, Mr. Velasquez.
Over here.
All right, have you heard from me?
Yes.
What did he say? What did your attorney say to you, sir?
Good morning, Judge. I'm his daughter, so I'm as far as the interpreter, I will be his assistant, but the attorney did not say. He said he was going to be present today.
All right, we'll try and find Mr. Cabanas. All right. Luis Ambriz, I believe, just clocked in.
Yes, Your Honor, that's my case. That's the one that you just called.
Right, okay. I'll mark him present. Julio Arguello.
He's currently in custody.
Thank you.
I'm sorry, that is a contested MTR set for today, Your Honor. We are ready on that whenever it's available.
Okay, what's your time announcement?
45 minutes. I've got one witness.
You have not turned in your timesheet. Please do so now.
And I have 2 witnesses, Your Honor. Probably 45 to an hour.
Yeah.
Kevin Pavelic.
I'm here for Mr. Pavelic, Your Honor. I spoke with him recently. I don't see him online yet this morning, so for now a no-show, but I think I'll have an update for the court soon on him.
All right, Richard Cerna.
I'm present for him, Your Honor. He is in custody. If you can mark us as conferring, I'd like to speak with Mr. Thornton for a little bit.
All right. Jasmine Thurman.
She is a no-show as well, I believe, Your Honor. Did not expect that also, so I will, if we could be on recall, update the court on her status.
I'll recall.
I'm here.
Okay.
All right.
She is present, apparently, Your Honor. We'll confer.
All right, please mute your phone, ma'am.
Okay.
Mercedes Alanis.
Jason Wolf here for Mercedes Alanis. I think it's a docket call, and we're asking for more time, Judge.
Okay, where's your client?
She tells me she would be on. She texted me about 8:45, 8:40, saying that she was ready to be on. So.
Okay. Well, I don't hear from her. I don't see her, but I haven't gone through all 59 participants. I'm going to mark her no show for the time being. Abby Oliva.
She's present here at the probation department, Your Honor.
That's a plea, Judge. Plea paperwork should be ready. Mr. Lamb has it.
Justin Schaefer.
Judge, that's mine. My name is Lee Cox. Mr. Schaefer, as if you remember, has been pretty much all over the state in different jailhouses. We finally have him here from TDC in Fort Bend County. We're trying to work out a plea here. We've got a plea offer from Mr. Lamb. We're going to see if we can work everything out, if we can possibly do a plea with him here in Fort Bend, if we get all the paper done on Zoom there somehow. We just need a new date.
Okay. All right. I'll ask you to get with the coordinator's office on a date.
Okay.
And I'll mark him custody in Fort Bend County.
Correct.
Oh, Ariola.
Judge, that case has been reset to January 27th.
All right. Mercedes Alaniz just appeared. I'll mark her as present. Robert Perez.
Your Honor, that's mine. Waiver of arraignment is on file. I've already posted the new date in chat. Mr. Perez, please announce.
Here. Okay. All right. Then you're excused for until whatever date we have. Luke Sanders.
Your Honor, he's in custody. The Addis goes to jail. I've already posted the new date on chat. It's the same date as Mr. Perez, 2/17.
Jesse Coronado.
Your Honor, that's the same announcement. We're resetting that case to the 16th for a plea.
Crystal Ferdine.
Your Honor, she's present here at the probation department.
Yes, Judge, and that'll be a plea this morning. I've posted the paperwork to chat.
Thank you. Adrian Shapa.
Morning, Judge. Robert Gear here. I've been in contact with Mr. Chapa. He was at the courthouse. I told him to drive down to probation, gave him the address. That should be a plea. I'm going to have to confer with him before that, but we should be entering a plea today.
All right. I'll mark him no show for now and I'll recall. Robert Tones.
Your Honor, he's in custody. Waiver arraignment's on file. I posted the new date in chat. May I be excused?
That's all you have. Yes, sir.
Thank you.
John Garcia.
Judge, I believe he's in custody. I have not gotten him to sign the waiver of arraignment, but the one I have is set for February 17th. I'd ask, if I plan to go the next couple of days to Atascosa County Jail and get him to sign it.
Okay, well, we'll set it for 2/17, but I want a monitor signing of the waiver date. So whatever the last day of the week is next week that we have criminal cases, let's put him on that. It's probably Thursday. Joshua Story.
Good morning, Your Honor. Judge, he's in custody. I've previously conferred with Mr. Thornton and we'd like to reset that to, I see that 1/27 is the date, so I'd like to reset it to that date.
Okay, if you will. Is that for a motion to suppress or?
Yes, Your Honor.
Okay. If you will post the cause number, name, and date in chat, that'll do it.
Yes, thank you.
Troxel is present.
Judge, I'm present on that. Ms. Troxel and several members of her family are suffering from the coronavirus at the present time. She is scheduled to go in the hospital. We are simply monitoring a waiver of arraignment on her. I would ask the court for a reset to monitor that, continue monitoring that, and allow her to be excused so that she can get to the hospital.
All right, she's excused and you may get with the coordinator's office for a date.
Thank you, Your Honor.
Thank you.
Tiffany Marie Tehran.
I'm here.
All right, Mr. Briggs.
Yeah, yes, Judge. we're going to simply ask that that be carried over to the next pretrial date.
All right, please get with the coordinator. Laura Jean Gonzalez. Did we get our waiver of arraignment in?
She's present here at the probation department.
It's in the queue, Judge.
All right, thank you. Okay, so just remain on docket. Remain on docket. She's excused. David Arocha.
That's a plea, Judge. He's in custody. Mr. Lamb has the paperwork.
All right, so how many pleas are we looking at?
Give me one moment, Your Honor. I'm going back through the docket.
Your Honor, on page 2, Christopher Aguilera, he's in custody.
Thank you.
I show 8 pleas, Your Honor.
Plus a contested MTR.
Yes, Your Honor.
Okay. All right, I'll let the attorneys for the state and the attorneys with no civil matters in the docket be excused to confer. Give me just a moment. The LaSalle criminal docket, matter of the marriage of Friesenhahn. Mr. Roberts, Mr. Dominguez, is that all completed?
No, sir. We have finished it, but we're making, I have gone over it a couple of times. We're still making a few changes to it. I will have it out this week. We've just been overwhelmed with stuff.
All right, I'll ask you to get with the coordinator's office and get an entry date for January.
Okay, thank you very much, Your Honor.
Once you get that, if you'll just post the cause number, just matter of the marriage of Friesenhahn and the date, you're excused. Mr. Dominguez, is he online or?
I don't
see.
No, I don't think so, Judge. I will advise him and get this to it.
Okay, all right, thank you. Okay, Atascosa's docket. Atascosa County versus Edwin Aaron.
Judge, the tax authorities are ready. Mr. Andres Cedillos is the attorney ad litem. I don't see him on. We sent him a copy of the judgment and all the information. Just announced an order to come after he reviews, Judge.
All right. In the interest of Ronald and Mary Haley.
Good morning, Your Honor. Derek Ritchie on that. I've got an agreed order to come.
All right, so just reset on request, or do you want an entry date?
Just an entry date, that would be great.
All right, if you'll get with the coordinator's office, and once you get that, if you will just post to me in chat, or to everyone is fine too, cause number, interest of Haley children, and the date, in that order, and nothing else, I'd appreciate it.
Will do, Your Honor.
Atascosa County versus the Ray Welch Foundation.
Judge, we're going to drop that. We need to amend in a new owner.
Your Honor, Sarah Ducker's here on behalf of the Welch Foundation. We had filed a disclaimer of the surface estate.
Okay. So I'll just put reset on request.
Thank you, Judge.
And you're down as the attorney of record. In the interest of Elijah Lopez, a child. Finkel, Mr. Vickers.
Yes, Your Honor. Sorry about that. We are set for the merits hearing today. I don't see Mr. Finkel.
Your Honor, I'm here.
Oh, there he is. All right. I'm not really sure. There's 2 issues, and I would say 30 minutes, maybe 45 minutes. I don't know what we're disputing exactly.
Your Honor, mark you 45 minutes in conferring. I'm sorry, Mr. Finkel, you had a different announcement?
Well, yes, I mean, I can confer, Your Honor, but I was going to announce not ready. The court had asked the parties to prepare logs the last time we were in court, and we have not been able to exchange those logs, and I'd like to have an opportunity to exchange those and be able to use them to question the witnesses.
Okay, I'll mark you confer and let you confer about that. Norma, were you going to be able to get off the phone and log in as on the computer?
Yes, sir. As soon as you finish calling the docket.
I'm taking everything down, so why don't you go ahead and do that now? Atascosa County versus Betty Angermiller.
Judge, the taxing authorities are ready. Ms. Hawkins is the attorney ad litem.
Yes, Your Honor, and I'm ready and my report has been filed.
All right, thank you. I'll take the tax cases together. San Miguel versus Peeler. What's your announcement for time today?
Your Honor, Mark Guthrie for Kiewit Mining Group. I can't speak for everybody, but I think we're looking at 3 or 4 hours on the motions to exclude Johnson and Brown.
Yeah, Louis Sutherland for San Miguel. I would agree with that announcement, Your Honor.
We also have a couple of carryovers that we didn't get to last week.
Well, we're not going to get to those today. I don't know how much time I'll have. So let me finish calling the docket. Atascosa County versus Victor Aaron Locke.
Taxing authorities are ready, Judge. Ms. Hawkins is the attorney ad litem.
And Judge, I'm ready and I have a report on file.
Thank you. Atascosa versus Carol Goldman.
Taxing authorities are ready. Lisa Voigt is the attorney ad litem. Andres Cedillos is listed, but he is not part of this case anymore.
All right, has Ms. Voigt filed the report?
We sent out everything to Ms. Voigt, and my understanding, she has not filed a report. It'll be an order to come on this, Judge, until she files a report.
All right. How long ago were Mr. Cedillos and Ms. Voigt appointed ad litems?
Mr. Cedillos is the original ad litem. We removed him and appointed Mrs. Voigt on this case. Let me see what the date was. Filed her answer on November 16th, 2020. I'm just still waiting for her report. She was appointed on order.
Okay, that's fine.
The 2nd, 2019.
So she was appointed in 2019 and just filed an answer last month?
That's correct. Yes, Judge.
All right, I'm going to remove all the ad litems so far who haven't announced and take them off the list.
Thank you, Judge.
All right.
I'm sorry, Judge. The appointment of Lisa Voigt was June the 16th of this year.
That's still too long. All right.
I'm sorry. I was looking at Andrea's appointment was May 2019. I'm sorry.
Okay, that's fine. That's still too long. Atascosa County versus Jesse Cantu.
Judge, the taxing authorities are ready. Mr. Finkel is the attorney ad litem.
Mr. Finkel?
He was on.
He is. Mr. Finkel?
I'm sorry, Your Honor. I'm not sure which one that was, but I'm not ready on it.
Okay. What do you need to do to get ready on this case?
Your Honor, I was in the middle of researching it and I need to file a report.
We'll reset this one.
Thank you, Judge.
Atascosa County versus Juan Balderas.
Judge, we need a drop that. Mr. Wilkerson is the ad litem. He's doing some additional due diligence on some owners, possible owners he has located.
All right, thank you. Atascosa County versus Estela Pacheco.
Taxing authorities are ready, Judge. Michael Finkel is the attorney ad litem.
Mr. Finkel?
Same announcement, Your Honor. I'm ready.
All right, Atascosa County versus Elizabeth Thompson.
Taxing authorities are ready, Judge. Mrs. Lisa Voigt is the attorney ad litem. We're still missing the report.
All right, I'm going to remove her from this case also. Atascosa County versus Helen Sweek.
Both taxing authorities and the attorney ad litem has already signed the judgment and filed the report. There was a pro se answer filed by the estate, which they indicated they don't want.
All right, Christopher Guzman.
Yes, sir.
I'm going to mute your phone or whatever you're on. Keep it muted. You understand? All right, go ahead, sir.
Item and the taxing authorities are ready, Judge. A pro se answer was filed, and in the answer, they indicated they did not want the property. We'll be entering a judgment today.
I'll mark that with the tax cases. All right, state Atascosa County versus Ronald Perry.
Judge, tax authorities are ready. Ms. Hawkins is the item.
And Judge, I'm ready and I have a report on file.
Thank you. Atascosa County versus Michael Herrera.
That's going to be a default judgment.
Atascosa versus Rochelle Ariando.
Also a default judgment.
Ex parte Gilbert Cruz. Expunction.
Judge, I'm present for Gerald Cruz Jr.
Oh, I'm sorry. You're right, Gerald.
And it should be agreed to. We're ready.
All right, I'll mark you number one.
Thank you, Judge.
Atascosa County versus Zoom Media LLC.
Judge, that's going to be a default judgment.
I take it there's no relation to the company we're on? Zoom?
I don't know, Judge, if they're the same company or not.
They ought to be pretty flush with cash right now. Atascosa County versus Integrity Gas.
That's going to be a default judgment, Judge.
In re Melissa Ramey. Writ of habeas corpus, Mr. Keendos. Anyone? I'll recall. All right. Anyone who was told to be here today, your case was not called.
Judge, Mercedes Alanis showed up.
Yes, I'm here. I'm present.
Okay.
As well as my client, Christopher Guzman. He was one of the first ones you called, Your Honor. He is on now.
I'm on here too. Gerald Cruz.
Hold on.
Judge, Gerald Cruz is the expulsion that I announced on.
Okay. All right. All right, so Christopher Guzman is present. Anyone else?
Mercedes Alanis.
Yeah, no, we have you, ma'am.
Michael Tejerina, sir.
All right, yes, sir. We have you marked as present.
Yes, sir.
Anyone else?
Judge, for my two cases called this morning, Edward Martinez and Ray Coronado on the criminal docket.
Okay. There's a Jesse Coronado.
No, it's a Ray Coronado.
No, we have no Ray Coronado on the docket.
Okay, what about Edward Martinez?
We had no Edwards that I recall.
Okay, then I must have gotten the Zoom information by mistake, Your Honor. May I be excused?
Yes.
Thank you.
All right.
Your Honor,
Yes.
on Melissa Ramey, we have her in custody.
All right. I made Norma the host. Anyone who needs a breakout room, please get with her. Okay, who is in custody?
Melissa Ramey, she was the very last one on the docket.
That's on the civil judge.
Oh. Oh, okay, I understand. There it is. All right, that's fine. I'll put her in custody, no show on Mr. Keendaws. Is the state still here?
Yes, Your Honor.
Do you have any idea, have you settled that with Sean or?
Mr. King Dawes and I had discussed that one before. It was an agreed order earlier. So I think this one may have just been an accidental add-on from previous time. If I can get a hold of Mr. King Dawes, I'll get a hold of him.
Okay, and you announced 7 pleas, 9 pleas, what was it?
It was it was 8 pleas, Your Honor. Actually,
I bracketed it, so go ahead.
Me and Mr. Barrera have discussed on page 2. There's an Angelica Elena Gutierrez who was originally set for a plea. Mr. Barrera announced that she was in custody. I've spoken to the jail. She was recently arrested for multiple new offenses. So the state's going to be rescinding the plea on that case. And we're going to discuss with Mr. Barrera some more as to what the new charges and new offenses would be.
Okay.
Yes, Your Honor. And so we'll just get a new date on her. This is not a new case, so I'll get a new monitoring date or something like that until we can figure out what the new cases are.
Okay. All right, and Norma, if you would make me the co-host, I'd appreciate it.
Your Honor, can I approach on Julio Aguejo, our MTR hearing quickly?
All right, hold on just a moment.
Sure.
So I'm looking here.
Judge, and I'm just sending you the ones that I have. There's not as many as they say, but I was waiting to see which ones we're going to plea out.
Chris, do you mind private messaging me which ones you do have?
Okay.
Thank you.
Okay. I think we have probably 3 or 3.5 hours worth of material with the state if we do all these pleas plus a 45-minute to an hour contested MTR. And probably 20 minutes with the other civil stuff, possibly another 45 minutes or hour if they don't get something worked out or there's no continuance on the Elijah Lopez case. So it's 9:30 now. That puts us to 1:30. I have to leave at 2. Pardon me, at 3 to take my younger son to an appointment. So let me ask the attorneys on Peeler. Do you want to come back later this afternoon, say at 1 o'clock, see if we get the pleas finished up early and try and get part of the day in today? Or do you want to try and find some time over the Christmas holidays to reset these matters for them? And you don't have to decide right this moment. You can talk about that among yourselves or in a breakout room if you want to. So, first case is the expunction case. Ex parte Gerald Cruz. Let me sign into the.
Yes. I'm sorry.
Okay, actually, sir, I need to at least leave Zoom and come back in. When I said I was having computer problems, whenever I got to Zoom this morning, it launched as normal. But when I try to minimize the screen, it tells me that I may not minimize the screen while I'm recording. Well, we've been recording since March, so we're not doing anything differently, but today I can't minimize the screen while it's recording, it tells me. And I can't get to the files that I need to get to, the icons on my desktop, without minimizing this. So I'm going to leave this meeting, launch the stuff so I can get into the district clerk's records in Atascosa County so I can look at all of these records, and then I will come back to the meeting, and hopefully it will not, if I'm no longer the host, still give me the message that says that it cannot minimize, so I'll be able to go back and forth and look. So I shall return as quickly as I'm able to.
I'm good.
Thank you.
Norma, would you be able to put Mr. Finkel and I in a breakout room? Are you still there?
Mr. Guzman, I got your reset date for, where is it? 2/17, okay?
Okay.
Okay.
So on February 17th, right?
Yes, sir.
All right. Thank you, sir.
But just answer your phone whenever I call you. We'll be working something out with the state later on, okay?
Yes, sir. So we're all done today?
You're done. You're good today, yes.
All right. Thank you, sir.
Thank you.
All right, 190800158 CRW.
Okay, I'm back, finally. And have the attorneys in the Peeler case, is there any consensus about whether you want to try and do what we can today? I don't know how long, if there's individual motions we might be able to get finished, or what are your all's thoughts?
Your Honor, we've been emailing, and I think folks would like to try to get at least one motion heard today. There's one shorter motion and then there are two longer motions. And I don't think there's an agreement yet about which one to take first. And the Peelers are agnostic on it, depending on how much time the court has.
Well, Your Honor, this is Louis Sutherland for San Miguel. I think I was the fly in the ointment, and I think both Ms. Whittle and Mr. Guthrie were okay with doing Mr. Zulu today and postponing Johnson and Brown, and sort of we'll stand out of the way. And I think Zulu is the one that probably makes the most sense to do today, and we can reset Brown and Johnson.
Your Honor, Mark Guthrie, Kiewit Mining Group, I agree with that.
Okay. All right then, so we will ask you to come back at, what is about almost 10, let's call it 1 o'clock, just see if we make it by then.
That's fine, Your Honor.
All right. Thank you. We'll see y'all at 1 o'clock. All right, let me see, the expunction case was.
Judge, I don't know if I can interfere, but who do I call to confer with the state, or because there's no breakout rooms that I don't know how can I get a breakout room to confer with the state on a case.
Okay. Norma, you're still the host, are you?
Yes, sir, I am.
All right. Get with Norma. She's with the coordinator's office. She's in charge of that. And Mr. Thornton, did I cut you off and never let you speak a while ago that you had an announcement on something?
Yes. Well, Your Honor, we were going to have the hearing for the contested MTR on Julio Arguello.
Right.
And my officer is on duty today, and an emergency situation has come up involving a group that he is part of that he has to respond to. And he has requested us give him a set time in the afternoon. And so I know that you had said you're out this afternoon. So I wanted to discuss that and see what we could to work out. He said that he's probably not going to be available till about 1 o'clock.
Okay.
And you know how those situations are too. So I'm hoping maybe we can come to some conclusion. Mr. Lambert has let me know that it's important to his client to get this done today. So I'm not sure what we can work out and how we can figure this out.
I'm not sure we can. We've got you saw all the attorneys that are here on the other case. How about Wednesday? My Wednesday afternoon has just freed up. I penciled myself to be at the retirement party for Sheriff Tackett, but due to COVID, they've canceled that.
Okay. I'm certainly good with that. I will check with him and get right back with you.
Okay, thank you.
Judge, this is Tim Roundtree. My client wasn't here when you originally called docket, but he's in now, and I just wanted to make that announcement to you.
All right, thank you.
And
I can go ahead.
I've already got a reset date from Miss Norma, which I've put into the chat.
Okay. Did you do that while I was in the meeting or while I was gone?
While you were gone.
Okay, if you would redo it, I would appreciate it, and then you're excused.
Okay, thank you, Judge.
You're welcome.
And Your Honor, my officer said that would work perfect on Wednesday afternoon.
All right, excellent.
Judge, good morning. I'm here on Mr. Ernesto Pineda.
Yes, sir.
I was on another court's Zoom docket call, Judge, but I just logged on to notify the court that I need to confer with the prosecutor. I sent the court the new reset date from Mr. Pineda. but I can send it again if the court would like.
Yes, I also need to know from you whether we need to have an interpreter. Because his daughter came on and said she was going to be acting as the interpreter.
That's right, Judge. Yes, we will need an interpreter.
Okay. All right. So what date did you get? Or it already has pretrials on 4/6? Was that from earlier this year?
I have 2/17/2021, Judge.
All right. 2/17 and interpreter. All right. Thank you. As soon as you send that back to me, you will be excused.
Thank you, Judge.
Remember, it's cause number, name, date. Thank you. All right. Ex parte Gerald Cruz.
Judge, he's present with counsel, and I believe it should be an agreed order. It was a pretrial diversion that was successfully completed. The case was dismissed, and I checked with the clerk's office, and they said all the parties have been served.
Okay, yes, I just went online. It looks like all the returns of service are there, and no one has filed an answer. So do you have your proposed order?
I can send it over to you, Judge, by email, or I can e-file it. I guess if there's a specific way that you want it.
If you could post it in chat, that would be the quickest way.
Okay, I'll go ahead and get that scanned and post it.
Okay. All right, whenever it comes to me in chat, I will sign off on it. So I want to put.
I guess once it's signed off on, I guess we don't need to do anything else. We'll just
No, I'll send it to the clerk's office, Ms. Benavides, and that should be it.
Okay. Do you still need my client present for the remainder of the hearing?
No.
Okay. Thank you, Judge.
You're welcome.
Thank you, Judge.
All right. All right, so let's start looking at the criminal cases. Who all do we have pleas on? Who's on the first page, anyone?
Your Honor, Jose Garza, the bottom one, is a plea.
Okay, and Mr. Briggs, is that part of what you sent to me earlier?
Yes, yes, Judge. I posted the paperwork to chat.
All right, thank you. Okay, and where is Mr. Garza? He's in custody?
He's in custody, Your Honor.
All right, if we could get him to the jail, to the Zoom room at the jail.
Yes, sir. We're going to get him right now.
Okay, and who's the next person in custody that we're going to have a plea on? Just so the jail will know who they need next.
Yes, Your Honor.
I have David Arocha in custody. He's the very last one on the docket.
Yes, Your
I've
Honor.
got Jacob Salazar in custody. He's somewhere in there.
He's also on the first page, Jacob Salazar.
And I can minimize Zoom now for some reason. Okay. All right, on the Jose Garza plea, I do not have the state's exhibit.
I'll send it over right now, Your Honor.
Same on Crystal Ferdine. And I'm looking at the papers on these cases and getting them ready. Let me know when they show up at the jail, please.
And Your Honor, I've sent over the violation report and the MTR on Mr. Garza to you.
How?
By email. Do you want me to send it to you by chat? I can do either. I can do both.
Let's try chat. I don't have it. I have 10:02. Chris Benavides sent me something. That's the last thing I have in chat. I mean, in email.
Oh, pardon me. That went to Chris.
Your Honor, I don't know. I was on mute.
All right, Mr. Tijerina, who is your attorney?
Mando Horta.
All right. Please remain on mute and please remove your hat for court.
Judge Jose Garza.
Okay. All right, give me just a moment to save this. All right, calling State versus Jose Garza. Are both sides ready?
It's ready.
Defense is ready.
Okay, are you Jose Garza?
Yes.
Are you the same Jose Garza who, on or about March 20th, 2019, was, is this a deferred or is this a?
Deferred adjudication, Your Honor.
Okay. Was placed on deferred adjudication probation for the state jail felony offense of possession of a controlled substance?
Yes, but I first got discharged, I think it was 2017 or 20.
All right, sir. I'm just asking if you were placed on probation, on deferred adjudication probation for 4 years on March the 20th, 2019 for a state jail felony.
Yes,
And you understand that on that day, the judge found there was enough evidence to find you guilty, but did not do so, and instead placed you on deferred adjudication. And if you complete that successfully, the case against you is dismissed. But the state has alleged that you have broken the rules for deferred adjudication probation. And if they can show that that is true, then you could be found guilty today and sentenced to anything that is a legal sentence for a state jail felony. That is 180 days to 2 years confinement and a fine up to $10,000. Do you understand that, sir?
yes. Yes,
And can you speak, read, and write the English language?
yes,
Now, the state has alleged that you violated rule number 17 of your probation in that you failed to perform community service restitution hours at the rate of 32 hours a month when you weren't employed or 16 when employed, and that you defaulted every month from April of 2019 through February of 2020. So do you understand what it is the state's alleging you did wrong?
yes,
You understand that the plea bargain agreement you have with the state is not binding on me. I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea. Do you understand that, sir?
yes.
Okay. All right, I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. And I want to ask you, on here on page 3, is this your signature?
Yes,
And do you swear or affirm that everything that above your signature on page 3 is true and correct?
yes,
Did you also sign plea bargain agreement?
yes, I did.
Waiver of time to file motion for new trial?
Yes,
Certification of appeal?
yes.
All right, and did you read these documents yourself or did your attorney, Mr. Briggs, read them to you?
I have read them myself.
Okay. Did you understand these documents before you signed them?
Yes,
Are you satisfied with the work that Mr. Briggs has done for you?
yes. The only thing I was asking, on my time, what do you call it?
Your back time.
Yes, that time, if that was correct.
We'll get to that.
Yes, sir. We'll let you raise that in just a moment. All right. Counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor.
All right. I'll find, sir, that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, to the allegation that you violated Rule 17 of your deferred adjudication by not performing community service restitution hours as you were required to do, is that true or not true?
True.
All right, I'll accept your plea of true and ask what evidence the state has to substantiate the violation.
State tender, State's Exhibit 1, it's Attachment A.
No objection.
All right, without objection, State's Exhibit 1 and its Attachment A are admitted into evidence. Do both sides rest and close at this stage?
State rest and close.
Yes, Your Honor.
Okay, I'll find that there is enough evidence to substantiate the violation, and I will also find that a change needs to be made in the disposition of this case. Are both sides ready for that hearing?
State's ready.
Ready.
Okay. is there a pre-sentence investigation or a waiver of one?
Waiver.
Okay. All right. What is the plea bargain in this case?
The plea bargain in this case, Your Honor, is for 10 months confinement in the Texas Department of Criminal Justice State Jail with 270 days credit.
All right. And go ahead, Mr.
That's correct, Your Honor.
Mr. Garza, did you hear what was read into the record by the state's attorney?
Yes, I did.
And is that your plea bargain? All right, and let me take out for a moment the number of days. Apart from the number of days, which there may be a disagreement on, is that your plea bargain?
It's 270.
All right, I'm saying ignore the number of days for right now. Apart from the number of days, is that your plea bargain?
Yes.
Okay. Now, do you believe that you're entitled to a number different than 270 days?
I thought it was more like 285, but.
Okay. And have the attorneys had a chance to review that?
Yes, Your Honor.
Okay.
I have not had a chance to discuss that with Mr. Lamb in detail as far as the back time.
Okay, let me ask you to just go ahead and you can either do that in a breakout room, or I can just mute my computer.
Your Honor, we can do it in a breakout room.
Okay, and I think Norma is still the host.
I'll put you on breakout room number 6.
Anybody else have an announcement that will move the docket along? Oh, I didn't go back to the civil cases. I'm sorry. I got off my track when I was working on the getting my Zoom relaunched and rebooting the computer. I'll come back to the tax cases after this plea.
Your Honor,
Okay.
just to inform the court, Adrian Chapa did show up to the probation department.
Okay. And Mr. Gear is just coming back in.
Morning, Judge. I heard my name.
Yes, Adrian Chapa.
He did make it? Okay, good.
So if you need to speak with him in a breakout room, please get with Norma.
Okay, I can call him on the phone, Judge.
Okay, go ahead. All right, Mr. Joyner. Did he leave? All right. Okay, Norma, can you try and download the expunction in Cruise that Mr. Joyner sent? I have looked at it. I've downloaded it, and my copy is corrupt, and I'm unable to open it.
Yes, sir.
Thank you. Okay, so what announcement do we have in the Jose Garza case?
I've announced it to, or I've told Mr. Briggs the time and dates that were specifically referenced. I'm not sure if he needs to speak to his client.
I do need a breakout room with Mr. Garza just briefly, Judge.
Okay, let me put you on one. Mr. Briggs in the jail, breakout room number 7.
Thank you.
Thank you.
Judge, I emailed you the expunction in case Norma has trouble with it.
Thank you.
Your Honor, I believe Mr. Garza and Mr. Briggs are back.
Yes, Judge. And can I have a brief breakout room with Mr. Lamb?
Yes, just
Breakout room number 8, Mr. Briggs.
Thank you.
okay. Ms. Benavides, I just sent the Gerald Cruz plea documents to you.
Okay, thank you, Judge.
All right, I see Mr. Garza is back. Is Mr. Briggs back? Or he's
No,
still
sir,
talking to Kenny?
they're still in a
He's talking
breakout
to
room.
Kenny now. He's talking to Kenny now, okay.
Norma,
Yes, sir.
can I have Mr. Garza at the jail again, please?
Yes, sir. Breakout room number 10.
Thank you.
Thank you.
Okay, Your Honor,
Yes.
on Mr. Garza, and I apologize for taking up the court's time today. I know it's a full day. He's asking if we could reschedule for Wednesday to crunch the numbers again and make sure we've got it right. We've still got a little bit of a discrepancy. And again, I apologize.
Okay, that's fine. So we'll reset this for 116.
Thank you, Your Honor. I'll post that in the chat.
All right. Give me just a moment. All right, and who's next? If we can get that person.
It's Jacob Salazar on the docket, Your Honor.
We'll get him right now.
Thank you. All right, let's go ahead and do the tax cases while we're waiting. Again, I'm sorry I got sidetracked. All right. Go ahead, Mr. Rocha.
Thank you, Judge. For those cases that we announced ready, we'd like to request a motion to consolidate for proof.
Without objection, they're ordered consolidated for proof.
And also, Judge, you take judicial notice on those parties that were going to be entering a default judgment, that they were served with proper notification by the Sheriff's Department. And also, we would like to include in all those that have an attorney ad litem of $495 attorney ad litem fee for their due diligence to locate the parties in question.
All right, I'll take judicial notice of the entire contents of all the court's files, and I'll approve that attorney ad litem fee for all of the cases that are disposed of today. And I'll ask you if you would prepare just a one-line order for me on the one with Mr. Cedillos and those with Ms. Voigt to substitute Megan Harkins. I would appreciate that.
Thank you, Judge. I will do so. Otherwise, Judge, we'll be filing all the judgments today. All parties were given notice. We'd like to enter a default judgment on those parties that did not file an answer, and also file for those who filed for the attorney ad litem, agreed judgment on those parties. Also, we have attached, and we'd like to introduce it in our exhibit as Exhibit A, are the certified tax statements from the Tax Assessor Collector's Office, certifying that those delinquent taxes are currently still due and pending, and allow us to foreclose against those delinquent taxes if need be, if no payment arrangements are into effect.
I'll admit all those into evidence and I will grant the relief prayed for. After I've had a chance to look at the district clerk's records.
Thank you.
All right, and on the ones with Mr. Finkel that are being reset, do we have a date?
I'll check, Judge. I have to go through, we're setting up our tax dockets for the next year, and I have several dates. Let me go through those real quick, and I'll send them to the court. If that's not an issue at a later time.
That's fine if you'll just post them in, yes, that's great if you'll just post them in chat to everyone so that he has notice of it also.
I sure will.
Thank you.
Thank you, Judge. I will get that information to you.
Thank you, sir.
Thank you.
Judge, we have Jacob Salazar.
All right. Okay, calling State versus Jacob Salazar. Are both sides ready?
Defense ready.
State's ready.
All right. Are you Jacob Roy Salazar?
Yes, sir.
Is that your true and correct name?
Yes, sir.
Mr. Salazar, are you able to speak, read, and write the English language?
Yes, sir.
And are you a United States citizen?
Yes.
Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Do you have any history of mental health problems or mental illness?
No.
Counsel, do you believe your client's competent to stand trial?
Yes, Judge, and he has, there have been some issues in the past, but he was released and deemed competent by a doctor recently, but there have been some mental issues in the past, but I do not believe they have hindered him from discussing his case with me.
Okay, thank you. All right, Mr. Salazar, you stand charged by indictment with the third-degree felony of assault on a public servant. Specifically, it is alleged that in Adams County, on or about January the 26th, 2019, that you intentionally, knowingly, or recklessly caused bodily injury to Isaac Morales, the complainant, by striking the complainant with your hand. And it's further alleged that the complainant was a public servant, a peace officer employed by Atascosa County Sheriff's Office, and that the complainant was then in there lawfully discharging an official duty. That alleges a third-degree felony, which is punishable by confinement for not less than 2 and not more than 10 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
Do you understand that the plea bargain agreement that you have with the state is not binding on me? I do not have to follow it, but if I do not follow it, I will allow you to withdraw your plea?
Yes.
Okay. If I do follow the plea bargain agreement you've worked out and the sentence I impose is not harder on you than what you've agreed to, do you understand that you will not be able to appeal this matter?
Yes.
All right. I want to show you some documents that appear to have your signature. They're titled Admonition to the Defendant for Court. Let me ask, on paragraph 2.11, is this your signature?
Yes, sir.
And where it says verification?
Yes.
And do you swear or affirm that everything that appears above your signature where it says verification is true and correct?
Yes.
And did you also sign on the certificate of appeal?
Yes.
The agreed punishment recommendations?
Yes.
The waiver of preservation of evidence?
Yes.
And the discovery compliance certificate?
Yes.
Did you read these documents yourself or did Mr. Adams read them to you?
Yes, sir.
Did you understand these documents before you signed them?
Yes.
And are you satisfied with the work that Mr. Adams has done for you in this case?
Yes, sir.
All right, counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence that he's making, and the consequences of his plea bargain?
Yes, Judge.
And do you also believe you've received all the discovery you're entitled to in a timely manner?
Yes.
Okay, I'll find that I have jurisdiction. I'll find that the defendant made his waivers of right and his stipulations of evidence knowingly, intelligently, and voluntarily, and I will also accept the discovery compliance certificates. And I'll ask you, sir, to the offense alleged in the indictment, third-degree felony assault on a public servant, do you plead guilty or not guilty? All right, Mr. Salazar?
Yes, sir.
To the offense that you're charged with in the indictment, third-degree felony assault on a public servant, do you plead guilty or not guilty?
Guilty.
Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No.
Has anyone harmed or threatened you or anyone close to you for your plea?
No.
Has anyone promised you an early release from your sentence?
No.
Okay. All right. I'll find that you made your waivers of, that you made your plea voluntarily, not any compulsion in making it, and I'll accept it. And I'll ask what evidence the state has to substantiate the
The
allegation.
state offers exhibit 1 and it's attachment A, Your Honor.
No objections.
All right. Without objection, state's exhibit 1 is attachment A, or admitted into evidence. Do both sides rest and close at this stage?
State does, Your Honor.
Defense does.
All right, give me a chance to look this over. All right, I'll find there's enough evidence to substantiate the defendant's guilt. And I will find him guilty at this time. Are both sides ready for punishment?
Yes, Your Honor.
Yeah, defense is ready.
Is there a precedence investigation or a waiver of one?
We waive it, Judge.
Okay. What is the plea bargain in this case?
The plea bargain agreement is for 3 years in the Texas Department of Criminal Justice Institutional Division. There's $315 in court costs. And there is credit for time served of 1,075 days.
Okay. All right, so Mr. Salazar, you heard what was read in the record by the state's attorney. Is that your agreement?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No.
And how many days is it?
1,075.
All right, so that's within a month of being a complete sentence. All right. All right then, anything else on either side?
Nothing from the defense, Judge.
No, Your Honor, there was part of the agreement where dismissing his other case, which is 17030197 CRA, and I'm emailing you the dismissal on that one.
All right, let me just add that here. It's dismiss what cause number?
It's 17030197 CRA.
All right, I added that to the agreed punishment. All right, then, I will find I have enough evidence before me to make a decision without a precedence investigation. I will follow the plea bargain in this case. I'll find the defendant guilty and sentence him to court cost plus 3 years confinement. Is there any legal reason why sentence should not now be imposed?
No, sir.
No, Your Honor.
Order, judgment, and decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent of the Department of Criminal Justice. You will be confined for a period of 3 years. Your sentence will commence this day. It will run concurrently with any other sentence you may be under, and you will receive credit for 1,075 days served so far on this case. You understand, sir, that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes.
Right, I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you've waived your right to appeal as part of a plea bargain and that you do not have the right to appeal. I wish you good luck, sir.
Thank you, Judge. May I be excused?
Yes. Okay, who's next up?
Your Honor, I was notified that on page 2, Andrea Webster should be in custody.
Okay. I had her as no-show, so she's in custody. Is she in Carnes? I mean, Atascosa?
Judge, she's in Atascosa. I saw her this morning, had her sign plea paperwork, so she's there.
Okay. All right. And she's next on the docket, apparently, if we can get Miss Webster.
Yes.
All right, so how many counts is the state proceeding on?
2 counts, Your Honor.
Okay, I see. So 10 for 4 on both.
Yes, Your Honor.
And is there a precedence investigation in this case?
Judge, we asked the court waive that. If we want to do any kind of evaluation for drug or alcohol counseling, that we do that after she's been released.
All right, calling State versus Andrea Webster. Are both sides ready?
State's ready. State is actually also going to submit a drug lab report to the chat right now, linked to this case.
And that's without objection, Judge.
All right, thank you.
And we're ready to go.
Okay. Are you Andrea Shea Webster?
Yes, Your Honor.
Is that your true and correct name?
Yes, sir.
All right, Ms. Webster, can you speak, read, and write the English language?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Okay, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes, sir.
Do you have any history of mental health problems or mental illness?
No.
All right, counsel, do you believe your client's competent to stand trial?
Yes, Judge, I do.
Webster, you stand charged by indictment with 2 different third-degree felony offenses. As to both, it is alleged that on or about May the 24th, 2018, in Atascosa County, that in count 1, you intentionally or knowingly possessed a controlled substance, methamphetamine, in an amount of 1 gram or more but less than 4 grams, and count 2, that you, knowing that an official investigation or proceeding was pending, intentionally or knowingly altered, destroyed, or concealed a pipe used for smoking methamphetamine with the intent to impair its availability as evidence in the investigation. I said, both of those alleged third-degree felonies, which in Texas are punishable by confinement for not less than 2 and not more than 10 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, I do.
Do you understand that the plea bargain agreement you've worked out with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, sir.
If I do follow the plea bargain agreement that you've worked out, and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter?
Yes, sir.
I'm going to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. And let me ask you on paragraph 2.11, is this your signature?
Yes, sir.
And at verification?
Yes, sir.
And do you swear or affirm that everything that appears above your signature where it says verification is true and correct?
Yes, sir.
Do you also sign on the certificate of appeal?
Yes. Yes, sir.
Agreed punishment?
Yes, sir.
And waiver of preservation of evidence?
Yes, sir.
And the discovery compliance certificate?
Yes, sir.
Okay, did you read these documents yourself or did Mr. Martinez read them to you?
I read it myself.
Did you understand these documents before you signed them?
Yes.
And are you satisfied with the work your attorney has done for you?
Yes, very.
Right. Counsel, do you believe that your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, Judge, I do.
Right. I'll find that the defendant made her waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily. And I'll also ask Mr. Martinez, do you believe that you've received all the discovery you're entitled to in a timely manner?
Yes, Judge, I do.
So accept the discovery compliance certificate.
Yes.
I'll ask you in count number 1, third degree felony offense of possession of a controlled substance. Do you plead guilty or not guilty?
Guilty.
Count number 2, third degree felony offense of destruction of evidence or tampering with evidence. Do you plead guilty or not guilty?
Guilty.
All right. Has anyone promised you anything other than your plea bargain with the state for your pleas of guilty?
No.
Has anyone harmed or threatened you or anyone close to you to get you to make these pleas?
No.
Has anyone promised you an early release from your sentence?
No, sir.
All right. You made your pleas voluntarily and you're not under any compulsion in making them, and I will accept them. And I'll ask what evidence the state has to substantiate the defendant's guilt.
State tender, State's Exhibit 1, it's attachment A.
Judge, that's without objection.
All right, without objection, State's Exhibit 1 is attachment A are admitted into evidence. Did both sides rest and close at guilt and innocence?
Your Honor, the state has also tendered what will be called State's Attachment B to the chat in reference to the Latins in this case.
And that's also without objection, Judge.
I had already added that to your A.
Then yes, Your Honor, just state rest and close at this point.
Defense rest and close.
All right, give me a second. I got too many things open here. All right, then, I'll find there is enough evidence to substantiate the defendant's guilt. Both sides for punishment.
State's ready.
Okay.
Defense is ready, Judge.
All right, and there's already a lab report attached to the Webster plea packet. Is this a different one that you tendered?
Yes, Your Honor. There was one that is labeled as Ruben Castro, which was, and then there's one for Miss Webster. And so the recent was for Miss Webster.
Okay, all right. So what is the plea bargain in this case?
The plea bargain in this case, Your Honor, are on both counts, confinement for 10 years in the Texas Department of Criminal Justice, probated for 4 years of community supervision. And on count 1 will be listed as a fine of $1,000, court costs of $315, crime stoppers fee of $50, 180 hours of community service, $60 drug court fee, drug offender education program, education, drug, and alcohol evaluation, monthly probation fee of $60, $180 restitution to the Texas Department of Public Safety, $50 drug testing fee, and the state and defense counsel have agreed to take off that section for the safety and remain in custody until transport. So that is not to be part of the plea bargain.
Oh, and just so the state knows, I went ahead and redacted that, and we initialed over it. And
that's also for, I know that the plea pack was sent to probation ahead of time, so that probation knows that there is not to be safety in this case.
Okay. And Judge, that's our understanding of the plea bargain.
All right, ma'am, I mean, did you hear what was read in the record by the state's attorney?
Yes, sir.
Is that your agreement?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
Right, and let me ask where Ms. Webster's been since the indictment.
Judge, let's see, since the indictment, she has had some terms of incarceration in both Kennedy County and in Bexar County.
Is that for felonies or?
Yes, Judge.
And was she on probation for any of those?
She was on probation out of Kennedy County, and that probation was revoked, and she was essentially given something close to time served. And then in Bexar County, she was sentenced to essentially the time she had served.
All right. And so, Ms. Webster, what are you planning to do differently on this period of probation than you did in your previous periods of felony probation?
Well, I was on probation in Kingsville, and there wasn't any type, the only reason why my probation was revoked is because the transfer of there to San Antonio, there was something wrong with my address, so I got revoked really quickly. And it's not that I failed any drug tests or wasn't going to any classes or anything like that. And I just chose to take the state time to get it over with. It was the first MTR that I had gotten there. But I mean, I'm not planning on messing up. I have a place to go. I have 6 children. I'm the only parent right now. So, you know, there's no room for me to mess up. I have a job waiting for me too as well when I get out.
And are you receiving, those children going to be in your custody or?
Yes, they are.
And do you receive child support for them?
I do not, but I have a child that is on SSI.
Okay, anything else on either side?
Nothing from the state.
Nothing from the defense, Your Honor.
All right. I will follow the plea bargain, except that I will zero out the fine. Let me ask, ma'am, where do you live?
655 Copla. in San-
I don't need the, I don't need the address. Just what county, what city?
Bear County.
All right. Your probation will be supervised out of Bear County. Now, I don't know what happened previously when you had a probation that was supposed to be transferred, but I can tell you that they're not going to come and put Mr. Martinez or your probation officer or I in prison if there's a problem in getting it transferred up to Bear County. It's going to be you. So you need to be proactive and make sure that you get that taken care of. The other thing I'll tell you is that I have reduced the fine from $1,000 to zero. Now, there's still other monies that you have to pay. I'm not at all telling you that it's not important to pay that money. It is, but I will tell you that if the only thing you're not doing correctly is you're not making 100% of your payments on time, we're not going to bring you back and have your probation revoked immediately just for that. We'll give you an opportunity to make larger payments towards the end of this 4 years if we have to. And if absolutely necessary, we could extend the period of time that you're on probation. So what I want to make certain is that you don't fail to go and see your probation officer just because you don't want to tell them you don't have the money to make a payment, okay?
Okay.
All right then. Anything else on either side?
Not from the defense, Your Honor.
Nothing
All
from
right.
the state.
So you understand, ma'am, that because I have followed the plea bargain agreement in these cases, these counts, that you've waived the right to appeal and you may not appeal?
Yes, sir.
All right, then I will find you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will certify to the Court of Appeals that this is a plea bargain and you waived the right to appeal and you have no right to appeal. Wish you good luck, ma'am. And actually, let me start. Go back and start posting the judgments that we've done. The please papers that we've done. Mr. Martinez, is that all you have?
Judge, that's all I've got this morning.
All right, you are excused.
Judge, Judge, I want to thank you for allowing us to get Ms. Webster in, as well as the state for expediting this so we can get her.
Sure, no, she's next on the docket, so.
Oh, no, that was her. Thank you, Judge.
Okay, all right. Yes, sir. Have a good day.
You too.
All right, give me just a moment. Okay, I just posted the plea packets in Salazar, Garza, and Webster to Ms. Benavides. Okay, who is next on the docket?
I have one in custody, David Arocha.
Me as well, Your Honor.
All right. All right. Let's see, the next ones are Aguilera, Coronado.
Aguilera's been reset, Your Honor. Or wait, no, sorry. Pardon me, Your Honor. Misspoke there.
And then Guzman, Talamantes.
Guzman wasn't set, Your Honor, for Christopher Guzman or another Guzman?
Yeah, I didn't mark down who was set for a plea, so I'm trying to figure out who's next in the docket.
Gotcha, sorry.
Aguilera, Mr. Gear is going to ask for a reset date on that one.
Okay.
Guzman was reset to 2/17.
All right, I'm just want to know who's the jail supposed to be getting over here now?
The next one on the jail, Your Honor, would have been, or should be David Arocha. He's the next plea.
You can get Mr. Arocha. All right, and did Ms. Figurs, did you have an announcement?
Yes, Your Honor. We are in the process of submitting a Rule 11 agreement, and my secretary's e-filing it right now. We're resetting to January 25th. And Mr. Finkel has agreed to produce something by Friday. That's all in the Rule 11 agreement. So unless there's a problem with January 25th, which I believe is your docket, this case has to be heard by you, then that should do it for us.
All right, so I will put down 125. All right, you are.
Thank you.
Someone would just post that to me in a chat with cause number in the interest of Elijah Lopez and the date, I would appreciate it. And then you're both excused.
Thank you, Judge.
And Judge, you do have Ricardo Jaramillo and Audrey Robledo on your list of pleas, right?
I don't have a list of pleas. I'm just, I was trying
Those
to.
are both jail cases as well that we have with Michael. They're both Michael Baird cases. They're both jail cases.
Don't believe Chris has gotten the plea packs on that one, on those.
No, I don't.
Oh,
That's why I haven't announced those. Sorry, Brad.
no problem.
Chad, you're not on mute. No.
Got him. And on David Arocha, I don't see anything listed on discovery.
It should have been listed as discovery packet, but
Oh, it just says discovery packets?
yes, Your Honor. On this one, Your Honor, it was this was an expedited plea work done with Mr. Perez.
Okay. Okay. I see it's just last month, yes.
Yes, Your Honor.
Was indicted, okay. All right, I'm gonna step away just for a moment. Hopefully he'll be here when we get back.
Yes, Your Honor. Just double checking with the jail. You guys are getting David Arocha.
All right. Calling State versus David Arocha. Are both sides ready?
It's ready.
Defense ready.
Are you David Arocha?
Yes, sir.
Junior?
Yes, sir.
All right. Mr. Arocha, can you speak, read, and write the English language?
Yes, sir.
And are you a United States citizen?
Yes, sir.
All right. Despite your representation that you are a United States citizen, and I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and/or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes, sir.
Okay. Do you have any history of mental health problems or mental illness?
No, sir.
All right. Mr. Perez, do you believe your client's competent to stand trial?
Yes, sir.
Okay. All right. You stand charged by indictment, sir, with the state jail felony offense of possession of a controlled substance. Specifically, it's alleged that on or about March 9th of this year in Atascosa County, Texas, that you intentionally or knowingly possessed a controlled substance, methamphetamine, in an amount of less than 1 gram. That alleges, as I said, a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide that I am not going to follow it, I will allow you to withdraw your plea?
Yes, sir.
Okay. All right, I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. Let me ask you, is this your signature on paragraph 2.11?
Yes, sir.
And at verification?
Yes, sir.
And do you swear or affirm that everything above your signature here on verification is true and correct?
Yes, sir.
Did you also sign at the certificate of appeal?
Yes, sir.
Agreed punishment?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
And on the discovery compliance certificate?
Yes, sir.
Okay. Did you read these documents yourself, or did Mr. Perez read or explain them to you?
Yes, sir.
Did you understand these documents before you signed them?
Yes.
And are you satisfied with the work that your attorney has done for you?
Yes.
Counsel, do you believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, sir.
And do you also believe you've received all the discovery you're entitled to in a timely manner?
Yes, sir.
Okay, I will find that the defendant made his waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I will also accept the discovery compliance certificate. Let me ask you, sir, to the allegation in the indictment, state jail felony possession of a controlled substance, do you plead guilty or not guilty?
Guilty.
All right. Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No, sir.
Has anyone harmed or threatened you or yourself or anyone close to you to get you to plead guilty?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
All right. I'll find that you made your plea voluntarily and you're not in any compulsion in making it, and I will accept it. And I'll ask what evidence the state has to substantiate the defendant's guilt.
State tender, State's Exhibit 1, it's attachment A.
No objections.
All right. Without objection, State's Exhibit 1, its attachment A, are admitted into evidence. Do both sides rest and close at this stage?
State rest and close.
Defense resting close.
All right. Give me a chance to look at the report. Okay, I don't see a lab report.
Yes, Your Honor. That's an agreement. This was an expedited indictment in this case with Mr. Perez, and with the understanding that there was not going to be a lab report tied to this case yet. The plea offer was for a time served.
That's right, Judge. He's been in jail for 10 months nearly, and he's ready to get out.
Okay, and what's happening with all of the firearms that were seized?
The firearms would be linked to the co-defendants, I believe, Your Honor, and I think they are still being held.
All right, I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for sentencing?
State's ready.
That's right.
Is there a waiver of a pre-sentence investigation report?
Yes, sir.
Okay, and what is the plea bargain?
Plea bargain in this case, Your Honors, for 9 months in the Texas Department of Criminal Justice State Jail Division with 280 days credit for credit for time served and judgment satisfied.
Okay. All right. Mr. Rocha, is that your plea bargain with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
Okay, now, Mr. Lamb, you said judgment satisfied. What is the Department of Corrections doing these days? By that, I mean.
They are currently paroling people out from county jail. And so.
Okay, that's great.
Yeah.
That's great. And this wouldn't even be a parole. It would just be a straight release, but they don't need him to show up just so they can do their own prints and photos.
I don't believe so, Your Honor.
Well, that makes a lot more sense, but that's not how it was just a couple of years ago. All right, then. Anything else from either side?
Nothing from the state, Your Honor.
All right, I will follow the plea bargain agreement in this case. I'll find the defendant guilty and sentence him to 9 months confinement. Is there any legal reason why sentence should not now be imposed?
No.
All right. It's the order, judgment, decree of the court that you be confined for a period of 9 months, receive credit for 280 days you've already been confined, so that sentence is fully served, plus court cost. You understand, sir, that because I have followed the plea bargain agreement in this case, that you've waived the right to appeal and you may not appeal?
Yes, sir.
All right, then I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily also, and I will approve them. And I will certify to the Court of Appeals that you've waived the right to appeal as part of a plea bargain and you may not appeal. I wish you good luck, sir.
Thank you, sir.
Judge, I have also Abby Oliva. She's at the probation office, but that's a plea as well.
Okay. Who's next on the docket? Who's in custody?
Those would be Michael Baird's clients, but I don't believe Chris has received the plea packs, nor have we. And I don't see Mr. Baird online.
Okay, give me just a moment to do the. All right, well then who's next after that?
Those would be pleas from the probation department. So at that point,
okay,
Abby Oliva would be available.
All right, whoever's first on the docket who's ready at the probation will be next then, but let me sign the judgments on Webster and get those filed.
Your Honor, do you mind if I make an announcement to get something off your docket for Julio Araujo? We had a contested NTR. I believe Mr. Thornton had asked to get it set for Wednesday in the afternoon.
Yes.
That's all I wanted to make sure and verify that, Your Honor.
Yes.
Thank you very much.
So we'll announce at 9, but plan on starting in the afternoon. Is that correct?
Sounds fine. Because like I said, I had a Sheriff Tackett's retirement party, but I just received a text since court started saying that that's being corrected. That's being put off or canceled because of COVID.
Okay.
Sounds good, Your Honor. Thank you. Thank you, Mr. Thornton.
Thank you.
All right, so that's Abby Oliva's next?
Yes, Your Honor.
Judge, can I make a quick announcement on
Yes, sir.
Tijerina, it's been reset by agreement to February the 2nd. I already sent the notice.
Okay, all right, thank you. You're excused.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you.
All right. In State versus Abby Oliva,
Yes.
right, are both sides ready?
It's ready.
That's right.
Right, give me a chance to look this over. All right, now, a couple of things. One, all of the signatures are typed. Is that correct?
Yes.
It is, Judge. Now, I sent it. I have Acrobat sign, which I email it directly to her, and it's all secured. So I have I have absolutely no doubt that she signed all of it. But
Okay, and that's fine. I was also going to say it came over to me with the signatures verified.
yes, sir.
The problem with that is it will not allow me to redact it. It will not allow me to make any changes to it, such as adding dates and signatures and things. So I want to ask another time, please don't do that. I appreciate you doing that. You would think it would be a good thing, but as it turns out, it's not.
Yes, sir. I'm sorry about that.
Like I said, you would think it'd be a good thing, but it's not. So what I'm going to do is I'm going to print this to a PDF, and then I will mark that up. Give me just a moment. Okay. Are you Abby Oliva?
Yes, I am.
Is that your true and correct name?
Yes, it is.
All right. Ms. Oliva, can you speak, read, and write the English language?
Yes, I can.
Are you a United States citizen?
Yes, I am.
All right. Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Okay. Do you have any history of mental health problems or mental illness?
No.
Okay. Counsel, do you believe your client's competent to stand trial?
Yes, sir.
All right, ma'am, you stand charged by indictment with a state jail felony offense of possession of a controlled substance. Specifically, it's alleged that in Atascosa County, on or about January 16th, 2019, you intentionally or knowingly possessed a controlled substance, methamphetamine, in an amount of less than 1 gram. That alleges, as I said, a state jail felony punishable by confinement for not less than 180 days, not more than 2 years, and by a fine up to $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes.
Do you understand that the plea bargain agreement you have with the state is not binding on me? You don't have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, sir.
On the other hand, if I do follow the plea bargain agreement that you have and the sentence I impose is not harder on you than what you've agreed to, you will not be able to appeal this matter. Do you understand that?
Yes.
And do you understand that if your plea bargain is for deferred adjudication probation and I was to follow it, I would find that there was enough evidence to say you were guilty, but instead of finding you guilty, I would defer or put off any such finding, and I would place you on deferred adjudication probation. And if you successfully completed that deferred adjudication probation, the case against you would be dismissed, and you might even be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested. On the other hand, if while you were on deferred probation, the state alleges that you have violated the rules of your deferred probation, then you could be arrested and brought back to court, and there would be a hearing on just that issue. Did you break the rules of deferred adjudication? And if the answer turns out to be yes, then you could be found guilty and you could be sentenced to anything that's a legal sentence for a state jail felony. 180 days to 2 years confinement and a fine up to $10,000.
Yes, sir.
Okay. All right, I'm going to show you some documents that appear to have your signature. All right. They're titled Admonition to the Defendant for Plea to the Court. And let me ask you on paragraph 2.11, is this your signature?
Yes.
And you understand, man, that that's a typewritten signature, but legally, any mark that you make to authenticate a document is a signature. So this legally is exactly the same as if you'd signed it with a pen. Do you understand that?
Yes, sir.
Okay. Did you also sign where it says verification?
Yes, I did.
And do you swear or affirm that everything that appears above your signature on verification is true and correct?
Yes.
And did you also sign on the certificate of appeal?
I did.
Agreed punishment recommendations?
I did.
Waiver of preservation of evidence?
I did.
And the discovery certificate?
I did.
Did you read these documents yourself, or did Mr. Perez read and explain them to you?
I read them myself.
Okay. Did you
You did explain the probation part to me too.
Okay. All right. Did you understand these documents before you signed them?
Yes, I did.
And are you satisfied with the work that your attorney has done for you?
I am.
All right. Counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, sir.
And do you also believe you've received all the discovery you're entitled to in a timely manner?
Yes, sir.
Give me just a moment. My Acrobat just crashed. All right, then. I'm not sure where I left off.
You asked if I received all the discovery in a timely manner.
Okay, and you did. All right, then I'll accept the discovery compliance certificate. I'll find that the defendant made her waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, ma'am, to the offense alleged in the indictment, possession of a controlled substance, state jail felony, do you plead guilty or not guilty?
For my probation?
Yes, is your plea guilty or not guilty?
Abby, to take the deal, you're pleading guilty,
Okay.
or you could plead no contest. No contest, same thing as guilty, though.
Okay.
But
No contest, yeah. Sorry, I didn't understand, really.
Okay. All right. So you understand, ma'am, as your attorney told you, pleading no contest might be different than a plea of guilty if you get into a civil lawsuit over what you were doing on the day in question, but that for all purposes inside this criminal case, a plea of no contest is the same as a plea of guilty. Do you understand that?
I do.
All right. Has anyone promised you anything other than your plea bargain with the state to get you to plead no contest?
No,
Has anyone harmed or threatened you or anyone close to you for your plea?
no,
Has anyone promised you an early release from your sentence?
no,
Okay, I'll find that you made your plea voluntarily and you're not in any compulsion in making it, and I'll accept it. And I'll ask what evidence the state has.
State tender States Exhibit 1, it's attachment A.
No objections, Your Honor.
All right, without objection, States Exhibit 1 and its attachment A are admitted into evidence. Do both sides rest and close at guilt and innocence?
State rest and close.
Defense rest and close.
Okay, I reviewed the attachments earlier while we were waiting to get started, and I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for sentencing?
State's ready.
Okay.
Defense ready.
Is there a pre-sentence investigation or a waiver of a pre-sentence investigation?
We'll waive it.
Okay, what is the plea bargain in this case?
The plea bargain in this case, Your Honor, is for 2 years deferred adjudication, a fine of $1,500, court costs of $315, Crime Stoppers fee of $50, 200 hours community service, drug court fee of $60, drug offender education program, standard drug offender conditions, education, drug, and alcohol evaluation, $60 monthly probation fee, the $50 drug testing fee, and restitution of $180 to the Texas Department of Public Safety.
All right, ma'am, you heard what was read in the record by the state's attorney. Is that your agreement with the state?
yes,
Did the state's attorney add anything or leave anything out?
no,
Okay, where do you reside, ma'am?
what does that mean?
What town do you live in?
I live in Bear County.
Okay. All right, so you understand that this case is going to be, you're going to have a probation officer in Bear County that you're going to have to report to?
Yes,
Have you been on probation before for anything?
I had a misdemeanor that I did a plea bargain with that too. It's over with tomorrow. I let my probation officer know about it, and she said it was okay. But that is one thing that it was a deferred.
Okay, so you've been reporting to your probation officer and doing well in that case?
Yes, I paid everything. Yeah.
All right, anything else from either side?
No, sir.
State.
All right,
Yes, sir.
okay. I'll find I have enough evidence to make a decision without a pre-sentence investigation report. I will follow the plea bargain agreement. I'll find there's enough evidence to find the defendant guilty, but I will not do so. Instead, I will place her on deferred adjudication probation for a period of, what was it?
2 years.
2 years, with all the rest of the terms and conditions of her plea bargain agreement with the state. All right, ma'am, you will be on probation in Atascosa County, but you'll be reporting to a probation officer up in Bear County. Make certain that you do that. You have to make payments under this probation. It's important that you make those payments, but if you're doing absolutely everything you're supposed to be doing except making those payments, you're not going to be adjudicated guilty just for that. We'll give you an opportunity towards the end of the 2 years to make a larger payment per month if you have to. And if absolutely necessary, we would even extend you for a period beyond 2 years. So I want to make certain that you don't fail to go and see your probation officer simply because you don't want to tell them that you don't have the money to make a payment. All right, so you understand that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right, I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily also. And I will certify to the Court of Appeals that you have waived the right to appeal and you may not appeal. I wish you good luck there.
Thank you.
That's all I have, sir. Can I be excused?
Yes, sir.
Okay, thank you.
Am I good too?
Yes, I'm sure you need probation, but you're finished with a court right now. Thank you.
Thank you.
All right, give me a moment to catch up on the judgments. Okay, Ms. Benavides, I have just posted back to you the waivers in the Oliva case and also the Webster judgments and the Oliva judgment. Let me look here.
Thank you, Judge.
Here's the Arocha judgment. Your Honor, I just had a chance to confer with Michael Baird about the Aaron Ray case. Do you have a second to discuss that? Give me just a moment. No problem. Put the digital signature on here. Let me get that done and all. Okay, I just posted the Arocha judgment. Okay, what case are we talking about, Ray?
Aaron Ray, yes, Your Honor.
Yes, what's going on?
And so it looks like we're not going to be able to come to a agreement on that. And I think the result is going to be a hearing that takes several hours to maybe more. So I know things have been really jam-packed here. We want to see if we can maybe get a setting on maybe a day where we don't have court, if any of those exist. If not, then need to try to plan for a day where we think we may have time for such a hearing.
All right, why don't you get with the coordinator's office and see if you can find a day between Christmas and New Year's?
Yeah, that would be fine, or really anytime in the foreseeable future. I will check with them and post it and get with Mr. Baird.
Okay, so who's next up?
Judge, I think I can relieve you of a plea today. My client, Crystal Ferdine, is needing to get back to Poteet, and she's about to lose her ride. If we could reset her for Wednesday, I believe we can do the plea then.
Okay, that's fine.
I'll post it to chat.
Thank you. So the only other person I think I have paperwork on is
Adrian Chapa, Your Honor.
Chapa. Is he in custody? Where is he?
He's at probation.
He's at probation, Judge.
All right, calling State versus Adrian Chapa. Okay, is he present in probation?
He is, Judge.
Okay, what box is he in?
It should come up when probation gets him the Atascosa County CSED.
Okay, so he's just not here yet. Okay.
He's not here yet. I don't believe so, Joe.
Okay, are you Adrian Chapa?
Yes, sir.
Is that your true and correct name?
Pardon me?
Is that your true and correct name?
Yes, sir.
Right. Mr. Shapa, can you speak, read, and write the English language?
Pardon me?
Can you speak, read,
Yes, sir.
write the English language?
Yeah.
All right, give me just a minute. Okay. All right, hold on just a second. I'm having computer trouble. Let me make sure I've got the documents here. Okay. Are you a United States citizen?
Yes, sir, I am.
All right. Despite your representation that you are a United States citizen, I need to caution you, sir, that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes, sir.
Do you have any history of mental health problems or mental illness?
No, sir.
Counsel, do you believe your client's competent to stand trial?
I do believe so, Your Honor.
All right, Mr. Gear, you stand charged by indictment with the state jail felony offense of possession of a controlled substance. Specifically, it's alleged that on or about May the 27th, 2019, in Atascosa County, Texas, you intentionally or knowingly possessed a controlled substance, cocaine, in an amount of less than 1 gram. Again, that alleges a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, Your Honor.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I do decide not to follow it, I will allow you to withdraw your plea.
Yeah, I understand.
You understand also that if I follow the plea bargain agreement you have worked out and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter? So you understand that if I go with the deal, you cannot come back later and say that you want to appeal.
Oh, yeah, I understand, yeah.
Okay. All right, I want to show you some documents that appear to have your signature. Oh, actually, to talk to you for a minute about deferred adjudication. You understand that if your plea bargain is for deferred adjudication probation and I was to follow it, I would find there was enough evidence to say you were guilty, but I would not do so. Instead, I would defer or put off any finding of guilt and place you on deferred adjudication probation. And if you successfully complete that, the case against you will be dismissed and you'll have no conviction. And you might even be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested in this case. But the other side of that is if, while you're on deferred adjudication, the state alleges that you have broken the rules, then you could be arrested, you could be brought back to court, and there would be a hearing on just that question. Did you break the rules? And if the answer to that turns out to be yes, then you could be found guilty. And you could be sentenced to anything that's a legal sentence for a state jail felony. That is anywhere 180 days to 2 years confinement and a fine not to exceed $10,000. You understand? Okay. All right. Now I want to show you some documents that appear to have your signature. They're titled Admonition to the Defendant for Plea to the Court. Let me ask on paragraph 2.11, is that your signature?
Yes, sir.
And at verification?
Yeah.
And do you swear or affirm that everything above verification is true and correct?
Yes, sir.
Did you also sign the certificate of appeal?
Yeah.
Agreed punishment?
Yes, sir.
Waiver of preservation of evidence?
Yeah.
Discovery certificate?
Yes, sir.
All right. Did you read these documents yourself, or did Mr. Gear read them to you before you signed them?
I read them, or he sent me an email and I read them on my phone. And then today, this morning, he went after him with me this morning.
Okay. Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Gear has done for you?
Yes, I am.
All right, counsel, do you believe you've received all the discovery you're entitled to?
I believe I have, Your Honor.
And you also believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
I do, Your Honor. He's been able to discuss his case with me at length.
All right, sir. I'll find that you made your waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them, and I will accept the discovery compliance certificate. And I'll ask you, to the offense alleged in the indictment, state jail felony possession of a controlled substance, do you plead guilty or not guilty?
Guilty.
Okay. All right. Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No.
Has anyone harmed or threatened you or anyone close to you for your plea?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
Okay. All right. I will, pardon me, find that you made your plea voluntarily and you're not under any compulsion in making it, and I will accept it, and I will ask what evidence the state has to substantiate the defendant's guilt.
State Tender States Exhibit 1, it's attachment A.
Defense has no objection, Your Honor.
All right, without objections, State's Exhibit 1 and its attachment A are admitted into evidence. Do both sides rest and close?
State rest and close.
Defense rest and close, Judge.
All right, give me just a moment to look over the reports. Okay. I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for punishment?
State's ready.
Defense is ready, Judge.
Okay, is there a pre-sentence investigation?
There is not, Judge.
Is there a waiver?
Defense will waive it.
Okay. All right, what is the plea bargain in this case?
The plea bargain in this case, Your Honor, is for 3 years deferred adjudication, a fine of $1,500, court cost of $315, Crime Stoppers fee of $50, 200 hours of community service, $60 drug court fee, drug offender education program, standard drug offender conditions, education, drug, and alcohol evaluation, and follow those recommendations. Monthly probation fee of $60, $50 drug testing fee, and restitution of $180 to the Texas Department of Public Safety.
All right, so you heard what was read in the record by the state's attorney. Is that your agreement with the state? All right, Mr. Shapa?
Pardon me?
Is that your agreement with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, they have it. It's still the same.
Okay. And where do you reside?
And
Where do you live?
on South Texas, the Valley.
Okay. So what county is this going to be? Super?
Excuse me, Hidalgo County.
And you understand, sir, you're going to have a probation officer in Hidalgo County. You'll also have one in Atascosa County.
Yeah.
The probation officer who'll make a decision about whether to send a letter to the DA's office saying that you're breaking the rules is the one in Atascosa County. And
Yes, sir.
they're not going to drive down to the valley to check up on you. So if they're getting pieces of paper from the valley that say that or emails from the Valley that say you're not following the rules, you understand they're just going to send those on to the DA's office?
Yes, sir.
Okay, anything else on my other side? That it?
No, sir. I appreciate it.
Nothing from defense, Judge.
All right, then I will follow the plea bargain agreement in this case. I found there's enough evidence to substantiate the defendant's guilt, but instead of doing so, I will place him on deferred adjudication probation for the time period with the conditions agreed to with the state. I want you to keep in mind what I told you, sir, about if you do what you're supposed to be doing, the case against you will be dismissed and you'll have no conviction. But that if you don't follow the rules, then you could be arrested and brought back to court. And if it's proven you haven't followed the rules, then you could be found guilty and sentenced from 180 days to 2 years and fined up to $10,000. The other thing I'll tell you is that it's important that you do everything, including make your payments. But if the only thing you're not doing is not making 100% of your payments on time, we will give you a chance to make larger payments towards the end of the time you're on probation. And if absolutely necessary, we could even extend the time you're on probation. So do not fail to show up just because you don't want to tell the probation officer that you don't have the money, okay?
Okay.
All right. You understand that because I have followed the plea bargain agreement that you've waived the right to appeal when you may not appeal?
Yes, sir. I understand.
All right. And I will certify to the Court of Appeals that you've waived the right to appeal as part of a plea bargain and you may not appeal. Wish you good luck, sir.
Yes, sir.
All right. How many pleas do we have left?
I believe that there's 2 with Michael Baird.
Is that all?
I believe so, Judge.
Okay. And that's Jaramillo and
I
Robledo?
show Robledo and Jaramillo, and then there's a Kevin Pawelek, but I didn't get the announcement earlier today.
All right. What's going on with Kevin Pawelek?
I have not heard from him today, Your Honor. I did expect to hear from him. Spoke with him a couple days ago. So I don't know what kind of issues he encountered or what the situation is, but I've been in pretty regular contact with him the last few months, 3 months. I imagine I'll hear something shortly by the end of the day.
All right. So right now we're looking at nice eye. Give me just a moment to sign this judgment.
Judge Robert Gear here. My other case, Christopher Aguilera, I put in chat, we're going to reset on agreement with the state to January the 11th. And that's all my cases. Can I be excused to go to Judge Ellison's court?
Yes, sir.
Thank you, Judge. Have a good day.
Okay. And
Your Honor,
go ahead.
it's Lisa Voigt, and I'm sorry,
Yes,
I
ma'am.
was in Judge Ellison's court earlier. I'm appearing for Laura Gonzalez, and we signed a waiver of arraignment with a new date of January 13th, and that should be in queue for signature there.
It is,
And-
Judge.
All right. Okay, for what day? Oh,
January the 13th.
yes, no, I had you, that is remain on docket, that was just to monitor the waiver and the clerk's office said it had been filed.
Okay. May I be excused?
Yes, ma'am.
Thank you.
All right, if someone will let me know when Mr. Mio gets there.
Judge,
Yes?
you were needing Ricardo Jaramillo?
Yes.
Okay, we're getting him right now.
Thank you.
Mr. Baird, did you send the paperwork to the judge, or who did you send the paperwork to?
I haven't, yes.
Oh, okay.
Yeah, we had some upload issues earlier, but I think we got it fixed.
Afternoon, Ms. Walters.
Hi, Judge. How are you doing?
Good.
I'm just bouncing back and forth between you and Judge Ellison this morning, seeing if-
Okay, I'd seen you briefly earlier.
Right. I think we are excused from his court, and I know that Molly sent us an appointment from Atascosa, but a new case, not one that's on the docket today.
Yes. I think I actually need to speak to Ms. Walters whenever I get a chance.
Oh,
It would be, I think it's Mr. Signs, right? I
let
haven't
me
received
look.
that one yet.
Give me a moment. Actually, Judge, I don't know who is the host on yours, but can you guys put me and Kenny in a breakout?
Let me do this plea, and then we can.
Oh, okay.
Yes, Norman is.
Yeah. Sounds good. Let me see which appointment that is, Kenny.
Mhm.
And Judge, they have brought in Mr. Jaramillo. They're ready.
All right, thank you. Give me just a moment. All right.
How much back time do I have on this?
We don't mind.
Okay, State versus Ricardo Rodriguez Jaramillo. Are both sides ready?
Defense is ready, Your Honor.
Okay, are you Ricardo Rodriguez Jaramillo?
Yes, sir.
Are you the same Ricardo Rodriguez Jaramillo who on or about July 26, 2017 was placed on deferred adjudication probation in this cause number for the felony offense, a third-degree felony offense of driving while intoxicated?
Yes, sir.
All right, and you understand that on that day you were found guilty and you were given a 10-year sentence probated for 6 years?
Yes, sir.
Now, the state has alleged that you violated rule number 2 of your probation. Specifically, their allegation is that you used alcohol during the time that you were on probation. So in which particular rule violation is the state proceeding on?
State is proceeding on rule number 2.
Okay, but there are a number of violations. Which one are you proceeding on? The first one, all of them?
Pardon me, Your Honor.
There's 4 violations of rule 2 alleged.
State will proceed on the first one.
Okay. All right, the state's alleging that on or about December the 15th, 2018, while you were on probation, that you used an alcoholic beverage. So do you understand what the state's alleging you did wrong?
Yes, sir.
Okay. And sir, can you speak, read, and write the English language?
What was that, sir?
Can you speak, read, and write the English language?
Yes, sir.
Okay. And you understand that the plea bargain you've worked out with the state is not binding on me. I do not have to follow it, but if I decide not to follow it, I'll let you withdraw your plea.
Yes, sir.
You understand that if I do follow the plea bargain agreement that you've worked out with the state, that you will not be able to appeal this to the Court of Appeals?
Yes, sir.
All right. I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent to Stipulation of Testimony. Let me ask you, on paragraph 3, is this your signature?
Yes, sir.
And do you swear or affirm that, actually on page 3, that everything that appears above your signature on page 3 is true and correct?
Yes, sir.
Okay. And did you also sign where it says plea bargain agreement?
Yes, sir.
And that the written waiver of time to file motion for new trial?
Yes, sir.
And on this certificate of appeal?
Yes, sir.
Okay. Did you read these documents yourself, or did your attorney read them to you?
We went over them.
All right. Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Baird has done for you?
Yes, sir.
Okay. You sure?
Yes, sir.
Okay. All right, counsel, do you believe that the client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor.
All right. Okay, sir, I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, to the allegation that you violated rule number 2 of your probation by using an alcoholic beverage while you were on probation, is that true or not true?
It's true.
Okay. I'll accept your plea of true, and I'll ask what evidence the state has to substantiate the violation.
State tender States Exhibit 1, it's attachment A.
No objections from the defense.
Without objection, State's Exhibit 1 and Attachment A are admitted into evidence. Do both sides rest and close at this stage?
State rest and close.
Defense rest and close, Your Honor.
All right, I'll find that the state has substantiated the violation of the probation and that a change needs to be made in the disposition of that case. Are both sides ready for that hearing?
State's ready.
Defense is ready, Your Honor.
Okay, is there a precedence investigation or a waiver of one?
No, defense waives, Your Honor.
All right, what is the plea bargain in this case?
The plea bargain in this case, Your Honor, is for 4 years in the Texas Department of Criminal Justice Institutional Division with 71 days credit.
All right, so you heard what was read in the record by the state's attorney. Is that your agreement?
On the 71, I think that was more time.
Okay,
If I could.
all right. So how much time do you, other than the time, is that your agreement? Other than the time that for credit for how long you've been in jail on this charge, is that your agreement?
Yes.
Okay. All right, and how much more than 71 days do you think you're entitled to?
I wouldn't know exactly as much. I don't know exactly how many days it is.
Okay.
The 9 months.
I'm going to ask your attorney, Mr. Lamb, and yourself to confer in groups of whatever is necessary. You know.
Mr. Thornton's back, so Mr. Baird and Mr. Thornton can confer on the days.
Okay,
credit.
that's fine. All right, well then Mr. Thornton and Mr. Baird can confer on that. And I want to stress to the defense attorneys, do not announce ready if you don't have an agreement on that, unless you're coming forward to tell me that you can't resolve it, even though you've tried, and you need me to make some sort of factual determination about how many days credit the defendant is entitled to, okay? So I'll let y'all start conferring.
Sure.
Do I have any more judgments coming or anything?
Your Honor, this is Attorney Jason Ditz. I'm sorry I'm extremely late. I'm currently in trial in Kendall County. I have a agreed plea on Richard. Sorry. Talamontes. And I'm wondering if we can reset this. It's a plea for jail time, so the client will not be
prejudiced. Okay.
Prejudiced anyway.
Wednesday.
We'll probably
trial.
We'll probably be out of trial by then. So can we set it for Wednesday, and then I'll let the court know if I'm still in trial at that time?
Yes. All right. So 12:16. If you'll go ahead, sir.
Oh no. I was going to ask Norma. I thought you were done with that.
All right. So 12:16, if you'll send me that in chat, you are excused.
Thank you.
Norma, can you put me in a breakout room with Ms. Walters?
Yes, sir. Breakout room number 3 for both of y'all.
Thank you.
Hey, can you guys put John in there too? J.M. Lamerson, please.
Yes, ma'am.
Thank you.
All right, Mr. Lamb, while we're waiting, let's see if we can start going over the docket because I wasn't keeping up for a while.
Yes. I guess Mr. Lambert.
Oh, they're back?
No, Mr. I was going to say to have Mr. Lamerson tell me that I was going to be a minute.
Oh, go ahead, do that one. Join them.
Okay. Thank you, Judge.
That's great.
And Your Honor, I think we'll be ready to continue shortly on this plea. The only issue there was Mr. Jaramillo completed a substance abuse treatment program. And so there's some credit he's entitled to. We just overlooked that before, but no other issues outstanding. Mr. Thornton says that we should have it cleared up in just a minute.
All right, excellent.
Thank you.
Okay, Judge, I think we have an agreement on the day's credit.
Okay, so we're back on the record. What's the agreement on days credit?
I'm showing 240 days.
All right. And Mr. Jaramillo, is that what you expect that you should have had credit for? You're muted, sir. I'm sorry.
Yes, sir.
Okay. All right, then. Anything else from either side?
Nothing from defense, Your Honor.
No, Your Honor.
All right, then. I will follow the plea bargain agreement in this case. The defendant has previously been found guilty of a third-degree felony offense of DWI subsequent offense, and I will sentence him to 4 years confinement in the institutional division. Is there any legal reason why sentence should not now be imposed?
No, Your Honor.
All right, it is the order, judgment, decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent of the Department of Criminal Justice. You'll be confined for a period of 4 years. Your sentence will commence today. It will run concurrently with any other sentence you may be under, and you will receive credit for, is it 272?
240.
240 days that you've already spent in jail on this charge. All right. You understand, sir, that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right, then. I will find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you've waived the right to appeal and you have no right to appeal. I wish you good luck, sir.
Thank you, Your Honor.
Thank you.
Okay, so who's next?
Mr. Bear, are you ready on Robledo? Have you got the paperwork on that, or?
Yes, yeah, we're all ready on our side as long as we have accurate numbers on her, like we talked about, for jail credit.
Yeah, I'm showing 245 days on her.
Okay, that's what we're looking at. Then we're ready.
I'll go grab her right now.
Thank you.
I'm sending you the judgment on Jaramillo.
Thank you. Let me get the Robledo. All right, calling State versus Audrey Desiree Robledo. Are both sides ready?
It's ready.
Defense is ready, Your Honor.
Are you Audrey Desiree Robledo? Are you the same Audrey Desiree Robledo who, on or about July 27th, 2015, was placed on 3 years deferred adjudication probation for the third-degree felony offense of evading arrest or detention?
Yes,
You understand, ma'am, that on that day, the judge found there was enough evidence to find that you were guilty, but did not do so. Instead, the judge put you on deferred adjudication probation, and if you successfully complete that, the case against you will be dismissed. But the state has alleged that you have violated the terms of your deferred adjudication, and if they can show that that is true, then you could be found guilty today and sentenced to anything that is a legal sentence for a third-degree felony. That is 2 to 10 years confinement and a fine up to $10,000.
yes,
Now, the state has alleged that you have violated your deferred adjudication probation. Specifically, they have alleged that you violated rule number 11. And what they are saying is that you failed to report to your probation officer the way you were supposed to do so on April the 11th, 2018. So do you understand what the state's alleging that you did wrong?
yes,
You understand that the plea bargain that you have with the state is not binding on me. I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
yes,
And that if I do follow the plea bargain that you've worked out with the state, and the sentence I impose is not harder on you than what you've agreed to, that you will not be able to appeal this matter?
yes, sir.
Okay. All right, ma'am, can you speak, read, and write the English language?
Yes,
I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent to Stipulation, Motion to Revoke or Adjudicate.
yes,
Let me ask, did you sign here on page 3?
yes,
And do you swear or affirm that everything that appears above your signature on page 3 is true and correct?
yes,
Did you also sign on plea bargain agreement,
yes,
waiver of time to file motion for new trial,
yes,
and certificate of appeal?
yes.
All right. Did you read these documents yourself, or did Mr. Baird read and explain them to you?
He did read it and explain it to me.
Okay. Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that your attorney has done for you?
Yes,
Counsel, do you believe that your, pardon me, do you believe that your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
I believe she does, Your Honor.
All right, I will find the defendant made her waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, man, to the allegation that you failed to report to your probation officer as required, is that true or not true?
true.
Okay. I'll accept your plea of true and ask what evidence the state has to substantiate the violation.
State offers Exhibit 1 and its Attachment A.
No objections from the defense.
All right, without objection, Exhibit 1 and its Attachment A are admitted into evidence. Do both sides rest and close at guilt at this stage?
Yes, Your Honor.
Okay. Defense rests and closed.
Okay. All right, then. I'll find that the violation has been substantiated and that a change needs to be made in the disposition of this case. Are both sides ready for that hearing?
Yes.
Okay.
Defense is ready.
Waiver of a precedent investigation?
Yes, it's waived, Your Honor.
Okay. What is the plea bargain in this case?
The plea bargain is for three years in the Texas Department of Criminal Justice Institutional Division, and there's 245 days credit for time already served.
All right, ma'am, you heard what was read in the record by the state's attorney. Is that your agreement with the state? Hello?
Yes, sir.
Okay, is that your agreement with the state?
Yes.
Did the state's attorney add anything or leave anything out? Anything else on either side?
Nothing from defense, Your Honor.
Nothing from the state.
I'll find I have enough information to make a decision without a precedence investigation. And I will follow the plea bargain agreement in this case. I'll find the defendant guilty of a third-degree felony of evading arrest or detention with a vehicle and sentence her to 3 years confinement. Is there any legal reason why sentence should not now be imposed?
No, Your Honor.
No, Your Honor.
Order, judgment, and decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent of the Department of Criminal Justice. You will be confined for a period of 3 years. Your sentence will commence today and it will run concurrently with any other sentence you may be under, and you will receive credit for all the time you have spent so far in jail on this charge. You understand, ma'am, that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right, then I will find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you have waived the right to appeal and you may not appeal. All right, I wish you good luck, ma'am.
Thank you.
Thank you, Your Honor.
All right, let me send something to. All right, Ms. Benavides, I'm sending you the Jaramillo judgment
Okay, Judge.
and the Robledo plea. And here's Robledo judgment. Let me get that saved.
Judge, did you send me the plea paperwork for Adrian Chapa?
I don't know. I will check.
I see the judgment on chat, but I don't think the plea paperwork is there.
Okay, I'll check. I'll check. Let me finish this one. All right, there's the Robledo judgment, and you asked for the plea paperwork on who? Chapa?
Yes, sir.
Okay, I just sent that. So what else do we have left?
I can go over the docket with you, Judge.
All right. So Audrey Robledo, final judgment.
Yes.
Tijarina 2-2. Jaramillo Salazar, final judgment. Jaramillo, final judgment. Brian, 12/1/21. Garza, final judgment.
No, Your Honor. Garza was reset to Wednesday,
Oh, okay, 12/16.
or the day's credit issue.
Okay, oh, we started, but I'd already stamped it final judgment. Got ahead of myself. Okay, Anthony, Seth, Ray.
Brad, did you and Mr. Baird get to a date?
We were working on that, and last I heard was Norma was going to check with the judge to see if he had any Fridays available in January.
Okay, the message I sent back was, I don't know, that they keep my calendar, so we'll just leave that
I'll
open.
get with you, Brad.
Okay.
And I'm still here, and just from our standpoint, it's not super urgent. As far as the time, the day of the week isn't critical, so yeah, we'll just follow up as well. That's fine.
Okay, Webster, final judgment. Aguilera, 111. Coronado, two of these, 12/16. Is Gutierrez 12/16 also?
Gutierrez is 113.
113. Guzman, 217. Talamantes, 12/16. Bazan and Breeze.
217.
Okay, and then Olson and Velasquez are also 217.
Yes, sir.
And Velasquez, we need an interpreter. Arguello, 12/16, contested MTR. Pavelik, Nisai.
Yes, Your Honor. State would ask the warrant to be issued and bond to be forfeited.
All right. Cerna, 217. Thurman is what?
I was not here for that date announcement.
Oh, I'm sorry, Judge. That was just the straggler client. The last one I haven't gotten to yet. I haven't put I never had a chance to put the note in there. 217 is what we're going to ask for. We're still working on a couple of discovery issues.
All right. Alanis, 217. Oliva, final judgment. Schaefer, Fort Bend County is my note. Do we have a date?
I do not have a date, Your Honor. I don't know if he spoke with Norma or I know that Mr. Cox had left, but.
All right, we'll check with him. Tell me he needs to get something accomplished. Ariola, 127. Perez and Sanders, 217. Coronado, 12/16. Ferdine, 12/16. Chapa, final judgment. Tones, I don't have anything.
217.
Garcia, 113, monitor waiver on both cases. And then Story and Troxel, 217.
Story, I show 127, Judge.
Okay.
Or the motion to suppress.
All right, 127, motion to suppress.
Is that right, Brad? With you and Megan?
Yes.
Okay, on who is that?
On Joshua James Story.
Okay. Go back up. Okay, 127 MTS, okay.
And Troxel was 217.
Right. Tehran, 217. Gonzalez, remain on docket. Rocha, judgment. Okay, so except for Mr. Baird's other case, that's it?
Yes, Judge.
Okay.
And Justin Schaefer with Mr. Cox, but
Yeah, we need to figure out what's happening with him.
Kenny, I didn't get anything on that matter with Mr. Cox. I had to log out for a little bit, so I'm not
Yeah.
sure.
I don't think I had anything on him. We, by our understanding, it is we're trying to figure out a offer with him. The state would be willing to reset this to a January date.
Okay, but I want to know, yeah.
Make sure with him, yes, Your Honor.
Sure.
I'll call Mr. Cochran now.
Thank you. Okay. I'm going to take a break. It'll probably be 10 or 15, probably 15 or 20 after the hour before I get back. So if somebody will, I don't know how many of the attorneys we have for one. Mr. Sutherland still shows to be on. Here comes Cody Schneider. I'll ask him to make announcements. Call it 15. In the all right, Mr. Schneider, now working up on the finishing up on the criminal side. I will be back 1:15.
1:15. Thank you, Your Honor.
Your Honor, just as a quick question, if we determine the date for Mr. Schaefer and for Mr. Baird's other client, may the state be excused afterwards?
Absolutely. Just have someone post that in chat, please.
Yes, Your Honor. Thank you.
And I'll also ask Ms. Benavides if you'll check and see if there's any other documents that didn't make it through. I'd appreciate that.
Yes, sir. I'll be doing that right now.
All right. I'll see you in a few minutes.
Okay.
Norma, do we need to discuss the date on that one case?
Yes, I'll have to look into his calendar. I can't get into it right now. I'll have to get it when Lori comes back. So I can send you an email and see what we can come up with.
Yeah, just email me and Michael Baird, and so that way we can all be communicating together. And we'll get.
Okay, give me 1 second.
How many hours do y'all think y'all need?
Probably 2 or 3.
Okay, so we don't want to put it on a regular docket. Y'all want a special setting on it?
We could if it was one that we know is not going to have a lot of stuff, but that's hard to predict.
I'll run the
so.
dockets. Yes, because they're all full, but I'll run the dockets and see what we have available, and then I'll send you an email.
Okay. Thank you.
Thank you. Yes, sir. Thank you.
Norma?
Yes, sir.
So I'm on the phone with Mr. Cox. He says that the date should be February 17th for Justin Schaefer. Do you want me to post that onto the chat just to everyone as well?
Yes, please. Yes, sir.
Okay. And
Thank
it should be reset to 2/17. Okay. All right. Thank you, Mr. Cox. Have a good one. Norma, I think that should be everything else. So if you need anything, feel free to give me a call.
Okay, very good. I appreciate it. Thanks.
Have a good one.
You too.
Hey, Norma.
Yes, ma'am.
I don't know. I've been in and out with you guys and Judge Ellison this morning, so I don't know everything that's been going on in here. Will you still need us this afternoon for anything, or are we good for us to just log out?
No, ma'am, you can log out. We're finished with the criminal docket.
Okay, perfect. Thank you. I'm gonna have
Yes, ma'am.
John log out too then. If you guys need me for anything, just text me.
Yes, ma'am. Have a great day. Thank you.
Thank you. You too.
Bye-bye.
Bye.
Hey, Bob, can you hear me? Hey, Bob?
Yes.
The judge is taking a little break. He's waiting until 1:15 to start.
Oh, okay. Thanks for letting me know.
Sure.
Okay. I'm back. Where do we stand?
Your Honor, are you referring to the San Miguel Peeler matter?
Yes.
I believe we're going to have one hearing today regarding the motion to exclude Simon Zulu.
Okay. All right. Can someone post that to me in chat, because I've been going, I have not looked. I saw one email that said something about a Dropbox. And is this the only thing that's been set so far this week, or do we have something tomorrow?
This is it for this week. Actually, you're rid of us until the new year, Your Honor.
Well, I don't know what your schedules all are. It might be able to come back between Christmas and New Year's at some time. I don't have court scheduled, so that would be a possibility.
I think we've negotiated all of the hearings at this point.
Okay, excellent.
And Your Honor, I just sent the link for the box.com material for only the Simon Zulu hearing for today.
Okay, thank you.
And please let me know if I name the files too long again or anything with those issues.
I ought to use that as an excuse to get the state to buy me a Mac. No, it's working. Apparently the response is large. Okay, there it went. Maybe my internet just slowed down. All right, it will. This was working. Let me try it now. All right, for some reason, it won't let me download the Peeler's reply, but I have printed that to a PDF, so let me get these open now.
And if Your Honor would like, I'd just send the Peeler's reply in chat if that's helpful as well.
Again, that's fine. I just printed it and that worked. Give me just a moment. Okay, who's going to be arguing these? Ms. Whittle and
Yes, Your Honor. I'll be arguing for the peelers.
In Your Honor, I'll be arguing Cody Schneider on behalf of Kiewit Mining Group.
all right, go ahead, ma'am.
Your Honor, the peelers move to strike and exclude certain opinions of Simon Zulu, a rebuttal expert and lay witness designated by Kiewit Mining Group. Mr. Zulu served as operations manager for Kiewit at the San Miguel Lignite Mine and also served as its corporate representative in this case. As the court is aware, it must apply different standards to assess whether a witness can testify as either a lay witness governed by Rule 701 or an expert witness, Rule 702. Under Texas Rule of Evidence 701, a lay witness may provide testimony in the form of opinions or inferences, but is limited to such testimony which is rationally based on the witness's own perception and helpful to a clear understanding of the witness's testimony or to determine a fact in the issue in the case. The court is familiar with the standard for expert testimony under Rule 702, which provides that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact and issue. While Kiewit has designated Mr. Zulu as both an expert and a lay witness, and such a hybrid designation may be allowed, it should not be permitted to offer Mr. Zulu as both an expert and a lay witness for the same topics. The risk is that Mr. Zulu will be allowed to offer impermissible expert opinions under the guise of him also being a lay witness. Nor should Mr. Zulu be permitted to offer opinions regarding causation, such as whether Kiewit's activities did or did not cause contamination of any of the peeler's damages when he clearly has no expert basis or foundation for those opinions, which he admits. Apart from his general knowledge, he did not undertake a separate process to arrive at his opinions. He did not speak with any other Kiewit employees in connection with developing his opinions, and he did not review the reports or testimony of any of the other expert witnesses in connection with the development of his opinions. According to Kiewit's designations, Mr. Zulu is designated to testify on the following topics, both as an expert and a lay witness. And I'll just show you our brief, Your Honor, so you can see these. So here, Your Honor, they've designated, this is from pages 2 and 3 of our brief, and these topics can be found at their request for disclosure, which we have attached to, as Exhibit 2. So here, Your Honor, Kiewit has designated Mr. Zulu as an expert and a lay witness for this topic on whether Kiewit performed its work at the San Miguel mine in accordance with good mining practices, industry standards, and consistent with Kiewit's standard of care. And then the second one, Kiewit has exercised reasonable care to avoid damage to the peelers and the peelers' property. That's expert topic number 3 and lay topic number 3. And then the third one, Kiewit properly accounts for, causes for proper transport of, and properly disposes of any solid or potentially hazardous waste generated from its activities at the Peeler Ranch. And this is expert topic number 4, lay topic number 17. And then the last one, Your Honor, where he's designated as both an expert and a lay witness, is that Kiewit performed its work at San Miguel in accordance with applicable state and federal laws and regulations and applicable permits. And then he goes on to list those. So Kiewit argues that it was not required to designate Mr. Zulu as an expert for matters for areas for which he is testifying based on his personal perceptions or opinions. But parties should not be able to conceal what should be expert testimony by claiming the witness is one whose opinions are merely for the purpose of explaining the witness's perceptions and testimony. We respectfully request the court not to permit Kiewit to toggle Mr. Zulu as both a lay and expert witness and fall within the requirements of Texas Rule of Evidence 701 or 702 at its convenience. The bulk of Kiewit's response to our motion focuses on a number of areas for which Mr. Zulu is designated as a lay witness only, but for which it argues that Mr. Zulu should be permitted to testify and offer opinions based on his personal perceptions, and because it claims the testimony would be helpful to the jury. But for an opinion to be rationally based upon his perceptions, Kiewit must establish that Mr. Zulu had personal knowledge of the events from which his opinions are drawn. His opinions are rationally based on that knowledge. Courts must weigh the complexity of the information from which the opinion was drawn to determine the helpfulness of the lay opinion to the jury. Here, there are four particular areas of testimony for which Mr. Zulu's lay opinion should be excluded as either unhelpful or not based on his personal observations. Number one, Kiewit has designated at least 4 topics for which it intends to offer Mr. Zulu's lay testimony as to causation of contamination or damage to the Peeler Ranch. Those include lay topic 13, 22, 24, and 25. Mr. Zulu opines that none of the alleged contamination on or under the Peeler Ranch results from activities or omissions by Kiewit, where Kiewit had a duty to perform or failed to do so. He opines that Kiewit has not caused or allowed pollution of surface or subsurface water on the Peeler Ranch. He opines that Kiewit has not created a nuisance to the Peelers as a result of its activities or adjacent to the Peeler Ranch. He opines that Kiewit has not endangered public health and welfare as a result of its activities on or adjacent to the Peeler Ranch. And 2 other topics touch on causation, lay topic number 15 and 16. He opines that Kiewit's limited obligations to San Miguel regarding handling and transporting coal ash on or across portions of the Peeler Ranch have not damaged the Peeler Ranch or the Peelers and have not created a dangerous condition. He also opines that Kiewit's limited obligations to San Miguel regarding the handling of water on the Peeler Ranch have not resulted in any damage to the Peeler Ranch or the Peelers. Now, Kiewit argues that Mr. Zulu may be permitted to opine as to causation to the extent his testimony provides opinions as to what events may or may not have caused the condition at issue. But the cases on which Kiewit relies involved far less complexity and necessary expertise from the subject matter for which Kiewit is attempting to use Mr. Zulu. Kiewit intends for Mr. Zulu to testify as to the cause of contamination on the Peeler Ranch, whether Kiewit's actions caused pollution to the surface or subsurface water, whether Kiewit's conduct has endangered the public health or welfare, and whether its actions in handling, transporting coal ash have caused damage or led to a dangerous condition. As this court has repeatedly heard in multiple hearings involving challenges to experts, the issues regarding the causes and extent of contamination on the Peeler Ranch requires expertise, which Kiewit has not demonstrated that Mr. Zulu possesses. As noted in the Peeler's motion, Mr. Zulu disclaims having an expert opinion as to the causes of contamination, nor has he or Kiewit undertaken any analysis regarding groundwater contamination, nuisance, or endangerment of public health and welfare. And while Kiewit is attempting to argue that his Kiewit does not cause it testimony is not a causation opinion, this argument is nonsense. Clearly, he would be testifying as to what was or was not a cause of contamination or damage to the Peeler Ranch. And so we think this lay opinion should be excluded. He does not meet the test for allowing it to be admitted. So the second set of opinions we think should be excluded, Your Honor, include Mr. Zulu's lay testimony regarding Kiewit's legal obligations. Kiewit argues that Mr. Zulu should be permitted to testify as a lay witness regarding Kiewit's obligations or responsibilities under its contract with San Miguel, and that such opinions are not inappropriate legal conclusions. But Kiewit's disclosures designate Mr. Zulu to provide testimony as to what its obligations were under contract or under its own amorphous Kiewit standard of care. These are lay topics number 1, 20, 21, and 23. While Mr. Zulu's testimony as to what Kiewit actually did, based upon his personal knowledge or what was required under its contract, would fall within Rule 701, he cannot be permitted to offer legal conclusions as to Kiewit's legal obligations under the contract or Kiewit's tort duties as a lay witness. The third area we think should be excluded is Mr. Zulu's testimony as to whether coal ash is a significant hazard. Kiewit has designated Mr. Zulu to testify that, in Kiewit's experience, exposure to coal ash dust has not been a significant hazard to persons or property. This is lay topic number 10. Kiewit argues that such lay testimony is permitted because he's speaking to Kiewit's experience and not offering an expert opinion based on environmental science or public health. Kiewit appears to concede that Mr. Zulu has no background, training, or experience to testify what constitutes a significant hazard to persons or property, or the dangers associated with coal ash dust. So it is left to argue that he should be permitted to testify as to what Kiewit's experience has been. But it's provided no basis to determine whether Mr. Zulu's information base regarding Kiewit's experience is complete, whether he actually knows what the dangers associated with coal ash contamination are, or whether his knowledge or Kiewit's experience is relevant to the actual conditions present at the Peeler Ranch. And Your Honor, this is precisely the type of expert opinion requiring scientific expertise and sound methodology that should not be permitted under the guise of lay testimony. The fourth area we think should be excluded is Mr. Zulu's testimony regarding what the Peelers knew or should have known. Kiewit has designated Mr. Zulu to testify, again as a lay witness, as what the Peelers knew or should have known on various topics. This is lay topic number 26. Mr. Zulu has never spoken to the Peelers. He has no knowledge of what their participation was in the historical events, including the permitting process leading to this litigation. That includes events which occurred before Kiewit was the mine operator for this site. His only knowledge appears to be based upon his limited review of permit-related documentation combined with his assumptions and speculation as to what the Peelers knew or should have known. Kiewit attempts to justify these opinions as ones which are rationally based perceptions, but it does not point to any testimony from Mr. Zulu which demonstrates he had any actual knowledge as to what the Peelers knew. Mr. Zulu's speculative testimony should be excluded. He seems to base his conclusion on the fact that under the permitting rules, landowners have to give their consent to certain activities. But that is just his general experience and assumption. Kiewit has not produced evidence that the Peelers gave such consent. In fact, this court has already determined the mineral lease did not allow for the off-lease ash disposal. And Mr. Zulu repeatedly testified no one at Kiewit ever read the Peeler lease. As a result, Mr. Zulu's testimony regarding what the Peelers knew or should have known or consented to should not be permitted. And just a last point, Your Honor, Kiewit argues that it was not required under the rules to disclose Mr. Zulu's lay opinions, and this court should not exclude his lay opinions simply because they opted to disclose them. But Kiewit and the other parties have filed a motion to strike the Peelers' lay opinion testimony regarding the cost of removal of coal ash, arguing that we did not properly disclose that the Peelers would be offering those lay opinions. So on the one hand, they claim there's no duty to disclose lay opinion testimony, and on the other hand, they claim we violated that same duty. That motion was supposed to be heard earlier this week, but it's been put off until January, Your Honor. I just want to flag it because at the same time that Kiewit is arguing we cannot move to exclude lay opinions, they have done the very same thing in a pending motion. So that's all, Your Honor.
Okay, Mr. Schneider.
Thank you, Your Honor, and I'll share my screen for a PowerPoint. With respect to the Peelers' motion to exclude Zulu, the summary of the argument is this. The Peelers initially only sought to exclude Zulu's lay witness opinions. So during the Peelers' argument a moment ago, when it was referenced that the bulk of the response was directed towards lay witness opinions, it's because the Peelers' own motion to exclude only sought to exclude lay witness opinions. And moreover, they tried to use the wrong standard to exclude those lay witness opinions, arguing only that they essentially should be excluded because they didn't satisfy the requirements for an expert opinion. Now, the peelers try to get a second bite at the apple and try to squeeze in new challenges to Mr. Zulu's lay witness opinions and other opinions as an expert. However, this court should not consider these new challenges in the reply because they're untimely. They were past the deadline to try to exclude any opinions in this situation. And in addition, you heard the peelers argue this concern about toggling between both expert and lay witness opinions. Well, Zulu and the Texas Rules of Evidence, Texas Rules of Procedure the Texas Rules of Evidence permit someone to provide both expert and lay witness opinions. And there is Texas case law to support that. You notice both in the peelers' reply and during their argument, they cite no cases to where someone could not offer opinions both as an expert and a lay witness. And quite simply put, Your Honor, these opinions by Zulu as a lay witness, they're admissible under Texas Rule of Evidence 701. Now, let's take a moment to just discuss Kiewit Mining Group's disclosures. As noted, Zulu was designated both as an expert and a lay witness with opinions. This is Mr. Zulu. He began his employment with Kiewit Mining Group in 2011. At the mine, he managed, organized, and supervised engineering personnel, operations personnel. He has over 17 years of experience in the industry, approximately 15 years in the mining industry. He's got a mining engineering degree as a bachelor's degree. He's got a master's degree in civil engineering. He's a registered engineer in training. He's a member of several mining and engineering associations, and he continues with his training and review of industry updates. Specifically with Kiewit Mining Group's disclosures, on pages 21 and 22 is Zulu's expert designations and what opinions he may offer at this trial, pages 21 and 22. And I want to point that out, and I'll be mentioning that several times during this argument, Your Honor. And on pages 21 through 22, what Mr. Zulu was designated an expert was for these 5 matters, 5 topics. As Kiewit Mining Group acted as a reasonably prudent operator, and I'm going to just paraphrase a little bit for the court because it's in the briefing and it's on the screen. Kiewit Mining Group performed its work at the mine in accordance with good practices, good mining practices, industry standards, and Kiewit Mining Group's standard of care. Again, Kiewit Mining Group's standard of care, not some tort standard of care. Also, he's going to be providing expert opinions on Kiewit Mining Group's exercising reasonable care to avoid damage to both the peelers and their property. In addition, Kiewit Mining Group properly accounted for, because it's no longer the contract mine operator, accounted for, caused proper transportation of, and properly disposed of any solid or potentially hazardous waste generated from its activities on the Peeler Ranch. And will provide an expert opinion about how Kiewit Mining Group performed its work at the mine in accordance with the applicable laws, regulations, and permits. Those are his expert opinions, Your Honor, that was designated. But Mr. Zulu was also designated as a lay witness, right there on page 17 of the Kiewit Mining Group disclosures. And then further on, starting on page 23. On page 23, Kiewit Mining Group disclosed that Mr. Zulu, along with 2 others, Mr. Silva and Mr. Kirk Rich, would, based on their personal perceptions and observations obtained while working at the mine, provide lay witness opinions under Texas Rule of Evidence 701. That started on page 23. And on page 23 through 25 is when Kiewit Mining Group disclosed potential lay witness opinions for 26 topics, Your Honor. And I know I'm pointing out very specific numbers and pages because it's important. Kiewit Mining Group disclosed 26 topics for potential lay witness opinions, and Mr. Zulu was designated as an expert for 5 topics and opinions. Oh, excuse me, Your Honor. Now let's talk about the Peeler's motion to exclude that was timely filed. In their motion to exclude Mr. Zulu's opinions, they noted on page 2 that Mr. Zulu was designated as an expert for 26 separate topics. Well, that's Simply not the fact, Your Honor. He was designated as an expert for 5 topics. The 26 topics deal with lay witness opinions. Then they cite pages 23 through 25 of Kiewit Mining Group's disclosures as the opinions that they seek to exclude. Again, pages 23 through 25 only dealt with lay witness opinions. Pages 21 through 22 were Mr. Zulu's expert designations. Now, these are the specific lay witness opinions that the peelers challenged in their motion to exclude. And you can see it deals with Kiewit Mining Group's standard of care and compliance with it. The coal ash is not a significant hazard. Obligations under the contract between Kiewit Mining Group and San Miguel, causes of contamination on the Peeler Ranch, and what the peelers knew or should have known before Kiewit Mining Group started at the mine. Now, that was under the motion to exclude, and it shows right there where those go towards the lay witness opinions. But the problem for the peelers' motion to exclude Mr. Zulu is they tried to exclude his opinions under Rule 702 only, saying he wasn't an expert to provide these opinions, which was the wrong standard. They tried to heighten the burden, Your Honor. As was discussed earlier during even the peelers' arguments, there is a different standards, different requirements for the admissibility of expert testimony and lay witness opinions. 702, the court knows very well, have to be qualified, have to have specialized knowledge, have to help a trier of fact. These are the requirements for admissibility as an expert for expert testimony. Rule 701 is very different. It allows a lay witness to provide their opinions or inferences rationally based on the witness's perceptions. And if it's helpful to clearly understand the witness's testimony or to determine a fact at issue. But again, the peelers in their motion to exclude failed to even mention Rule 701. They applied the wrong standard. They tried to heighten the burden for the admissibility of these lay witness opinions. So after we provided a response, the peelers try to save face with the reply containing new challenges, Your Honor. So let's talk about the peelers' reply. In their reply, for the first time, they challenge how Kiewit Mining Group, Mr. Zulu's expert opinions for how Kiewit Mining Group exercised reasonable care to avoid damage, and how his opinions will be about, expert opinions will be about Kiewit properly accounting for how they transport and dispose of any solid waste or potentially hazardous waste. And his opinions, his expert opinions relating to Kiewit Mining Group's performance of its work at the mine being applicable to laws and regulations and the applicable permits. It was the first time they challenged it. And those are on pages 2 to 3 and 5 of their reply. Again, they did not challenge these opinions either as an expert or lay witness opinion in their motion to exclude. It was simply untimely. And the court should not consider those arguments and those challenges now. They shouldn't get a second bite at the apple. And then they provide a comment on page 3 of their reply, essentially saying that Kiewit Mining Group shouldn't be allowed to have Mr. Zulu provide expert testimony and lay witness opinions because it essentially would be concealing something. Well, again, Kiewit Mining Group never concealed any of this material with respect to Zulu. It's not concealing that Mr. Zulu is going to provide expert opinions or what potential lay witness opinions that he's providing. It provided advanced disclosures of that, even when it didn't need to. And it timely did so and properly disclosed it. And that's a distinction I want to focus in on for a second. With respect to the coal ash removal evidence that the peelers, since the peelers brought up in their motion, the reason that is being sought to be excluded is for a litany of reasons, but it certainly was not timely disclosed. It's a completely new damage model. And it's not the basis of being a lay witness opinion and how they can't provide a lay witness opinion. It's simply, and they try to do it as an expert opinion as well, they try to squeeze in a new damage model months and months after the timely deadline to disclose it. And that's all I'm going to say about that right now, because we're going to have a whole hearing on that I think should wait until then for allow the other parties to hone in on that. But it is very, very different. Now let's talk about what the peelers concealed until they brought up their new challenges in their reply. They either concealed these, they withheld them, or they simply did not initially intend to challenge these opinions. And they only thought of these ideas after recognizing that they failed to challenge the 26 lay witness opinions under the proper standard and requirements to, again, save face. And they conceded that they failed to properly challenge these opinions. On page 4, Your Honor, you can see right here, this is from their reply. The appealers concede that they did not challenge Mr. Zulu's expert qualifications as to these other matters. Then on page 5, while not explicitly identify appealers' motion to strike, the following 2 topics also touch on causation. They didn't challenge these in the motions. They shouldn't get a second bite at the apple, and it just would be improper and untimely to allow them to do so. And let's discuss this toggling argument by the appealers for a second. This toggling argument, it's not based on any Rule 701 requirements, perception or helpfulness. It's not based on any Rule 702 requirements, qualifications, relevance, and reliability. It's this made up standard about how they shouldn't allow toggling between opinions back and forth. That's just not a justifiable basis. They don't provide any case law to address that. And moreover, the appealers, if they are sincerely concerned about the jury or trier of fact being unaware of which opinion might be a lay witness opinion or which opinion might be an expert opinion by Mr. Zulu, that can be addressed in cross-examination by simply asking him, Mr. Zulu, when you were testifying about X, was that your expert opinion, or were you just providing that opinion as a lay witness? And it's addressed simply at that matter, Your Honor. Again, the appealers cite no case law or other support that Zulu can only testify for these opinions as an expert or a lay witness. However, there is case law supporting Kiewit Mining Group's position right there at Osborne v. State. A person with specialized knowledge may testify about his or her observations under Rule 701 and may also testify about the theories, facts, and data used in his or her area of expertise under Rule 702. And this court can also look to the Reed Road Municipal Utility District number 2 versus Speedy Stop case as well, supports that a person can provide both expert and lay witness opinions. Now let's talk about the lay witness opinions that are still being challenged by the appealers. As the court noticed, it seemed that all of these lay witnesses' opinions that were challenged by the appealers and argued about were that they shouldn't be allowed as expert opinions. And none of the causation opinions, lay witness causation opinions, the contractual opinions that were challenged, you notice each time they were arguing that Mr. Zulu didn't have the expertise or it was a legal conclusion. It was these types of expert reasons, these expert exclusions. But let's talk about the lay witness opinions by Mr. Zulu relating to Kiewit Mining Group's contractual obligations with its contract with San Miguel. In their motion to exclude, Your Honor, they say it on page 6, Mr. Zulu can certainly provide testimony about his understanding of those contractual or contract obligations and how he has acted upon them as a fact witness would be able to do so. That's what he's doing. He's not providing a legal conclusion, Your Honor. He is, from his perception, providing an opinion, an inference, on what occurred and what the obligations were for Kiewit Mining Group under its contract with San Miguel. Again, that's only a lay witness opinion. That is not designated as an opinion for his expertise. Only a lay witness opinion.
Okay, and what exactly did KMG say he was going to be testifying about with regard to that?
Within his disclosures, Your Honor, what was going to be testified about was, and it, as brought up by the screen right now, it's going to be the contractual obligations of, under the contract, it states that Kiewit Mining Group needs to do X. And Kiewit Mining Group performed X. And Kiewit Mining Group was required under the contract to follow the obligations under the mining permits. And I'm paraphrasing, Your Honor, but these are, as he expanded upon it a little bit during his deposition, is why I'm kind of referring to that. But in general, Kiewit Mining Group basically said a lay witness opinion about Kiewit Mining Group's obligations under the contract with San Miguel that was performed at the mine, the obligations. And he provides additional information that could be discussed with these lay witness opinions based off of his perception. It wasn't just on the contract, it wasn't just the permit, but also the practices between the parties. That's from his personal perception. That can only be gained from his personal observation or experience. And that concerns a subject matter outside the common knowledge for a juror. So that's why it'd be helpful for a jury. That's what makes that lay witness opinion, that perception, admissible under Rule 701. And just because he's providing an lay witness opinion about the obligation, a contractual obligation, doesn't automatically mean it constitutes a legal conclusion. In Holland versus Memorial Hermann Health System, there was a senior VP and chief facility service officer who provided a lay witness opinion about the responsibility of the hospital compared to what the contract was with the landlord. And he was testifying not about whether Memorial Hermann owed a duty to Holland in that case, but instead to the landlord, which is similar to what Hewitt Mining Group will have Mr. Zulu provide a lay witness opinion on. And it was based on, in that case, the chief facility service officer's personal knowledge. Same thing here with Mr. Zulu. It's going to be based off his personal knowledge of the contract between Hewitt Mining Group and San Miguel and how those obligations were performed and what was performed under the contract, permit, and under the practices. Now, let's talk about—
There'd be a difference between knowing who you call when a light fixture goes out and understanding what the obligations are under a mining lease, a lignite lease, especially when the peelers are complaining that there were obligations that weren't carried out at all?
Well, from my understanding, I don't want to take the words out of the peeler's mouth, but it's my understanding that there were obligations in tort with respect to what some duty that Hewitt Mining Group allegedly owed the peelers. What Mr. Zulu is going to be explaining and was Hewitt Mining Group's obligations for this particular lay witness opinion, Hewitt Mining Group's obligations to San Miguel. To help explain the background of Hewitt Mining Group is a contractor to San Miguel, what the obligations were between Hewitt Mining Group to San Miguel and the permits and that kind of purview of what Hewitt Mining Group was doing out there and the opinions about what those obligations were. So it doesn't get expanded upon without his testimony.
Are you?
Sorry, Your Honor. You froze up on me there for a second. I apologize.
Okay. All right. It says, okay, am I back?
Yes, Your Honor. I apologize.
Okay. So is Mr. Zulu going to be offering any opinions as to whether KMG violated the terms of the lease, or is he simply offering opinions as to whether KMG lived up to its contract with San Miguel?
The latter, Your Honor. He's not going to provide any opinions whatsoever about the mining lease, the buffer zone lease, or anything like that, because he doesn't have any personal knowledge of that. He doesn't have anything that he did personally involved with that. As Ms. Whittle provided earlier, he didn't even review that mining lease. He's not going to provide any opinions on that. It's just what the obligations were between Hewitt Mining Group and San Miguel, Your Honor.
And that would not exclude the possibility that San Miguel failed to require KMG to do things that it should have been, that San Miguel had an obligation to see that were done, that San Miguel owed an obligation to the peelers to see that were done.
Again, I don't believe Mr. Zulu would have the ability from his personal observations and understanding of what the mining lease would have required or anything like that to provide that type of lay witness opinion. Again, it would just, the universe would be limited to Hewitt Mining Group's contract with San Miguel, Your Honor. So, and again, he's not going to provide a legal conclusion on any of that, but just what those obligations were under the contract and how they basically were performed.
Go ahead.
Thank you, Your Honor. And with respect to Mr. Zulu's lay witness opinion about causes of contamination, I want to be very, very clear here. Mr. Zulu is not going to provide any expert opinions about what caused or didn't cause the alleged contamination on the Peelers Ranch. Mr. Zulu is not going to get on the witness stand and say, I went out there and took soil samples and water samples and tested it and reviewed the testing and came up with the conclusion that X caused this alleged contamination, or there's no contamination at all. Mr. Zulu's lay witness opinions relating to the causes of contamination, again, are limited to his personal observations and activities when he was out there as an employee of Hewitt Mining Group, basically saying, I was out there, I saw Hewitt Mining Group do this, I saw it perform good practices, and based on my observations of those activities, it's my opinion that Hewitt Mining Group could not have caused contamination at least the areas that the peelers are talking about. And that's very different, Your Honor, than stating Mr. Zulu is going to provide an opinion on what actually caused the contamination. He's not a scientist in that sense. He's not going to be doing any of that. And we're not saying he's going to provide an expert opinion on that. He's just going to provide a lay witness opinion about what he saw out there, and he believes Hewitt Mining Group would not have caused that. And Your Honor, Rule 704, Texas Rule of Evidence 704, doesn't make an opinion excludable simply because it embraces a potential ultimate issue. And Your Honor, with respect to this potential causation opinions, lay witnesses do this. For example, it's more common with car wreck situations. And regarding of the complexity of it, Mr. Zulu is not going to, again, provide a complex expert opinion about chemicals and PCLs being exceeded or any of that. He's not going to provide that type of complex opinions that other experts have been designated for. He's not going to do that. He's just providing a lay witness opinions of what he saw out there and his opinion on those activities not causing the alleged contamination. And similar in a car wreck case, a witness who is just a lay witness opinion can provide an opinion going, well, I saw this person do this, and that's what caused the wreck. In the Merrill versus Sprint Waste Services case in the Texas Houston Court of Appeals, that's exactly what this person did. She provided an opinion based on her perceptions that the two parties were equally at fault, and that was admissible. Mr. Zulu is going to do the same thing here. Now, with respect to the coal ash dust not being a significant hazard, again, Mr. Zulu is not going to provide an expert opinion about this, and we didn't designate him for an expert opinion about this. This was, again, just a lay witness opinion, and it's going to be based off of his observations, his perception. He's not providing any type of expert opinion based on environmental science or public health. Instead of, it's his experience and his observations during his time at Hewitt Mining Group and knowledge of Hewitt Mining Group's experiences. He's been there since 2011. He can provide his opinions from personal observations that what he has seen as being part of these mining operations, that he's not seen a significant hazard in these situations. But again, he's not going to go up there as a doctor. He's not going to go up there as a scientist and say this. He's going to say, in his opinion, as somebody who's been in the mining industry, he hasn't seen this. He hasn't seen these type of hazards.
Isn't that like someone testifying that they've been smoking cigarettes for 50 years and they don't see that it's caused them any issues?
It could be similar to that, Your Honor, but again, with the lay witness opinion, it doesn't have the type of weight that an expert does. It's not if you have an expert go up there and go, well, these studies show that smoking cigarettes cause cancer. Somebody who's been up there and say, for me personally, from my experience, when I've gone out there and smoked a cigarette, I haven't gotten cancer. They're providing an opinion on their personal experience, and they're permitted to do so. Now, if they try to go a step further and say cigarettes won't cause cancer because they don't have the chemicals in there, and how could they cause cancer? Somebody can't do that without a medical degree. What he can do, though, is say from his personal experience, he himself has not seen cancer being caused to himself. And that's his opinion. But again, it's not an expert opinion, it's a lay witness opinion about it. And with respect
are the counter defendants denying that coal ash is a hazardous material?
I'm sorry, say it again, Your Honor.
Are the counter defendants, San Miguel and KMG, are they denying that coal ash is a hazardous material?
With respect to coal ash and the hazardous material, it's my understanding, there's a very specific term for with respect to coal ash, and it's not hazardous material from what I understand. And I apologize, I should know the answer to this off the top of my head, but that area has been more left up to the experts to opine on what the specific name and designation of coal ash. I believe it's under the federal statute, it's considered, and I apologize, Your Honor, I'm just blanking right now. It's considered a potential matter that has to be handled a certain way, but not necessarily a hazardous material. And
Your Honor, we can concede that EPA has declined to make a decision one way or the other, whether coal ash is hazardous or not. Congress set up a process for EPA to study coal ash to determine whether it's called a hazardous waste material and regulated under Subtitle C of RCRA. And the EPA has never concluded that process. They have kind of kicked the can down the road since the 1970s on it. So that's why it's regulated under Subtitle D of RCRA, which is for solid waste, not hazardous waste. I think that's what Mr. Schneider is referring to. But I think that Mr. Zulu's opinion goes to whether coal ash is harmful. And that seems to me a different matter.
Yeah, and the only thing I would add to that, Your Honor, since you asked about the counter defendants generally, is that, hazard is the issue that is addressed in the TERP rules that we spent a lot of time talking about on Thursday. And I think the scientists look at this in both from a human health standpoint and an ecology standpoint of, anything can be a poison. The dose makes the poison is the characteristic thing that toxicologists will tell you. And so it all depends upon the amounts and the exposure pathways and what you're trying to protect.
And Mr. Zulu hasn't done any of that analysis, Your Honor.
Go ahead, Mr. Schneider.
Thank you. And I appreciate Mr. Sutherland, Ms. Whittle for chiming in there. Thank you. And with respect to that, Your Honor, with Mr. Zulu, again, the hazard, and I'll go back one. It's not that he's providing an opinion about that. He's providing from his experience, his observations, his knowledge of Kiewit Mining Group's experience. He's providing a lay witness opinion about that. He's not trying to override the EPA or TERP or anybody else on the definition. He just doesn't have that expert experience to do that. And we're not saying he does. We're just saying off of his general observations during his time of working for Kiewit Mining Group, working out there in the mine, he hasn't seen a significant hazard arise in this situation. Now, with respect to his lay witness opinions, again, about the peelers, what they knew or should have known, again, that's not an expert opinion. And Mr. Zulu is not trying to read anybody's mind. He's simply opining to the peeler's state of mind. And it has been held that Texas courts have consistently had the opinion that an opinion or inference testimony, which is what lay witness testimony is, a lay witness opinion or inference about another state of mind rationally based on their perception, is admissible under 701, which is exactly what Mr. Zulu does here. His opinions or inferences on what the peelers knew or should have known was rationally based on his perceptions drawn from his observations of preparing permits being issued before Kiewit Mining Group got there, the photos of the area, the Peeler Ranch before Kiewit Mining Group's arrival, and his experience with this permit process and the publications required and these procedural steps that are necessary that involve the landowner. So based off of his personal kind of perceptions, he is getting an inference, a rationally based inference that the peelers either knew or should have known about these matters. It's not an expert opinion. It's simply based off of his perception, Your Honor. And with respect to any argument
okay, and hold on. What matters exactly did he opine that the peelers should have known about? I mean, I agree they should have known there was a lignite plant there, but what exactly did you say they should have known about?
With respect to his lay witness opinion, and let me just go ahead and bring that up. I'll just go ahead and it's right here, Your Honor. Again, on page 25. The peelers knew or should have known since before Kiewit Mining Group commenced working for San Miguel on the Peeler Ranch in January 2011 of the storage of coal ash in these areas on the portion of the mining area A on the Peeler Ranch from lignite, which has been mined off the Peeler Ranch based on the appearance of available images in those areas and the fact that the peelers knew that the removal of lignite from mining area A on the Peeler Ranch was completed in 1990. Again, he's able to make those type of opinions based off his perceptions and inferences of the permits, of the publications required. This is what he's providing that the peelers knew or should have known about. That about the storage of the coal ash in areas that they should have known or knew or should have known about, the removal of lignite and when it was ended and completed. And And that's what he's going to provide an opinion about in this situation, Your Honor. Not whether the peeler should have known that there was contamination on their property or not. Again, he's not an expert. He doesn't have the specialized knowledge on that to be able to do that, Your Honor. And with respect to his opinions, sorry, Your Honor.
Go ahead.
With respect to his opinions about, let me start the slide here. You know what, we'll just go ahead and keep it up here to not try to go back and forth too much. With respect, there is an argument with respect to his opinions about good mining practices and industry standards and Hewitt Mining Group's standard of care, provided both as a lay witness opinion and an expert opinion. Again, the peelers shouldn't be able to challenge that now because they didn't challenge it necessarily in their motion. Now, but with respect to this opinion, regardless, it's unquestionable that with respect to these matters, it was rationally based on his perception gained through his personal observation and experience while working at Hewitt Mining Group in the mine. And if it's going to be an expert opinion, which is one of the designations for an expert opinion, it's undeniable that he's qualified to provide these opinions, Your Honor. And again, the peelers didn't challenge his qualifications on this. And undoubtedly, it's going to help the jury understand his testimony and fact issues, because this type of information about mining practices, industry standards, Hewitt Mining Group's standard of care is outside the realm of common knowledge for the jury. And it's going to be helpful in the situation with the tort and the statutory tort claims regarding alleged duties and purported duties that the peelers are going to insert in this case. And finally, I want to address with respect to the lay witness opinions. Again, Texas Rules of Civil Procedure under Rule 194 only require disclosures of opinions by experts. So Hewitt Mining Group wasn't even required to disclose these lay witness opinions. They included it just to provide it and put it out there. However, Hewitt Mining Group should not be punished now for these advanced disclosures by precluding Mr. Zulu's lay witness opinions about these matters. And again, this position is very, very different than the rationale and the reasons that are being provided by the counter defendants for the reasons to exclude the coal ash removal estimates, Your Honor. And Your Honor, if you don't have any questions, that's all I have for this time.
All right. Thank you. Ms. Whittle?
Yes, Your Honor, there's no doubt that Hewitt's disclosures are confusing, and we think that's by design. They want to obfuscate whether Mr. Zulu is testifying as an expert with the experience and training necessary to develop the opinions they have disclosed, or whether he's testifying as a lay witness based on his own rational observations. They want our experts to have studied the site for 45 years and written a dissertation on it, but they want Mr. Zulu to testify that Hewitt did not cause this harm based on no study whatsoever. They shouldn't be allowed to confuse things in this way, and there's a real risk because Mr. Zulu has technical training and experience, just not in the 4 areas we are asking the court to exclude. He will appear to the jury to be an expert when he is not, especially since they will be attempting to qualify him as an expert on mining operations. We move to exclude Mr. Zulu's opinion testimony as to whether coal ash is harmful, what the contract means, the causes of contamination, and the peeler's knowledge. Whether those are expert opinions or lay opinions, he does not meet either test, and those opinions should be excluded. While a witness may be designated as a lay witness to offer lay opinion testimony and expert opinion testimony, you don't see them doing that on the same topic. And that is our concern here. Thank you, Your Honor.
Okay.
And Your Honor, just briefly, those toggling concerns, one, like we discussed earlier, is not a basis or requirement under either one of the rules. And further, as discussed previously, those confusion issues, which can easily be addressed from cross-examination. And again, Your Honor, there is case law supporting that a person can provide opinions as both an expert and a lay witness, Your Honor. And that is why this court should deny the peeler's motion to exclude Simon Zulu's lay witness opinions that they sought with their motion and their late attempts to try to exclude his expert and lay witness opinions, Your Honor. Thank you.
Okay, I will try to get this out shortly. And if you said you already reset dates for everything that got bumped this week and last?
Yes, Your Honor. I think we've agreed on everything at this point.
All right, then. I will see you next year.
Thank you. Have a good year.
Thank
Happy
you,
New
Your
Year.
Honor. Happy holidays.
Yes, ma'am. You too. All right. Here's LaSalle clerk. I'll release everyone else. LaSalle district clerk's coming in.
Judge, and I already got everything that was for today's court on the criminal side.
All right. Thank you.
Thank you. May I be
Lachey, you-
excused?
Yes, you too, Lachey.
Okay.
Okay, LaSalle district clerk.
Yes, sir.
I saw you signed on. What's going on?
I think we had one case this morning. I think I missed it.
Yes, and they still don't have it ready. They gave me 1/21/21.
Okay, thank you, Judge.
Yes, ma'am. Have a good day.
Thank you.